Okay, great. Okay, now you can switch it to me.
Thank you.
Got it on her.
Oh, you're welcome. Take that state hat.
Got it on her.
You're welcome.
Am I the host now, Gwen?
Yes, Your Honor.
Thank you so much.
Welcome.
Morning.
Good morning.
Has anybody ever heard of Neil Brand?
No, sir.
No.
Ms. Nelson, have you ever heard of Neil Brand?
No, Your Honor.
Hey, Gwen, do we have a Brand as an attorney on our list?
Not that I see, Your Honor.
Okay. All right, first up is Ms. McCoy. Ms. McCoy, who do you have?
Good morning, Your Honor. So I have Hope, it's Hope Ellis. I talked to her partner. He said that she had a matter that she was taken over to the Berrien County Jail. So it's set for PCC. So I probably wanted to have an adjourned PCC.
Is there a possibility this may resolve itself short of an exam?
I talked to her partner. I don't know. So I have discovery. I need to talk to her. He said that they got her from the Wayne County Jail, but then she had a matter in Berrien County that I saw she had. I think she's on probation there. So
okay, let me call the case.
Okay.
Go ahead, Gwen.
Calling case 230-602-5201, the people of the state of Michigan versus Hope Ellis. The defendant is charged with count 1, police officer assaulting, resisting, obstructing. The defendant has an habitual offender status since notice. Today is the date and time for a probable cause conference. Appearances, please.
For the people, P number 049.
And good morning, Your Honor. Robin McCoy, P63057, on behalf of Ms. Hope Ellis. She is not present at this time. I did talk to her partner. He said that she was transferred over to the Berrien County Jail. We are asking for an adjourned PCC so I can have time to talk with her. I do have the discovery in this matter.
And Your Honor, Your Honor, if I may, this case is a resisting obstructing case. That is the only charge. There's no domestic violence associated with this. So I'm actually asking that this matter be transferred to another courtroom just because of that reason.
All right, it doesn't meet the criteria to be in this courtroom, Ms. McCoy, so we're going to find out where this case is supposed to be at.
Okay, that's fine.
In the meantime, maybe I will go ahead and adjourn the probable cause conference. I'll adjourn it to December 15th, and in the meantime, we'll find out what judge you're supposed to be with.
Okay, all right. Thank you, Your Honor.
Mr. Woodyard.
Judge, good morning. I'm here with APA Hicks. We have a competency review for my client, Mr. Malik Smith.
Okay, we're ready on Smith.
Calling case 230-594-3601. the people of the state of Michigan versus Malik Smith. The defendant is charged with count 1, homicide, murder, first degree, premeditated. Count 2, weapons, felony, firearm. Today is the day and time for a competency hearing. Appearances, please.
Good morning, and may it please this honorable court, APA Jonathan Hicks, appearing on behalf of the people, P85288.
And Judge, good morning. Michael Woodyard, my P number is 64612. I'm a staff attorney with Neighborhood Defender Service of Detroit, and we represent Mr. Smith.
Okay, do we have a report back from the forensic center?
We do, Judge.
What's their findings?
The report opines that he is competent at this time.
Mr. Woodyard?
Your Honor, I've received the report. I've reviewed it with Mr. Smith. I don't see him on the screen. I have reviewed it with him, so it would be fine, I think, with me if we waived his presence, and I would agree that the report accurately states the opinion of the examiner.
All right, the court makes a finding that the defendant is competent to stand trial. We'll set this matter for, are you demanding a preliminary exam?
Yes, please.
The court will set this matter for preliminary examination. How's January 9th?
That would work for the people.
Judge, that date is fine with Mr. Smith and I.
Okay, you have the choice between 10 o'clock, 11:30, or 1:30.
1:30 would work best for me, as I have another matter scheduled for the morning, but I can be flexible.
No, the afternoon is fine, Judge. I'll see you at 1:30 the afternoon on the 9th.
Okay, January 9th at 1:30. Bond will be continued. Thank you.
Thank you, Judge.
Thank you, Judge.
Ms. Nelson, good morning.
Good morning, Your Honor.
Who do you have?
I'm here on Cordell Walker.
Okay. Ready on Walker?
Is he in the waiting room?
No.
Okay. I'll waive his presence for the purposes of this hearing.
Let me call the case.
Calling case 230-602-6001, the people of the state of Michigan versus Cordell Walker. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence. Today is the date and time set for a probable cause conference. Appearances, please.
Good morning, Your Honor. The people, P number 6049.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service on behalf of Mr. Walker, P77960. I would waive Mr. Walker's presence for the purposes of this probable cause conference.
The court will waive the defendant's presence. What's your pleasure?
Your Honor, I'd like to set this matter for a preliminary exam.
Okay, the court will continue the plea of not guilty and set this matter for preliminary examination. Is your client in or out?
He's out, Your Honor.
Okay, how's January 8th at 9 o'clock?
I'm in trial that day, Your Honor. The 8th, 9th, and 10th, I'll be in trial. I could do it the previous week.
What about the 12th?
I can do the 12th. 9 a.m.
Okay, January 12th at 9 o'clock, yes.
Your Honor, I've received paper discovery, but no digital discovery. Ms. Dreen, do you know if I'm going to be receiving that soon?
I don't have any digital. I don't have access to any digital discovery at this time. I'm going to ask the officer in charge to send it as soon as possible, and then I'll send it to you.
Thank you.
Thanks.
Looks like I saw Miss Silver walk in. Are you still there, Miss Silver?
I'll get her.
Okay. Wayne County Jail, what's your name, sir?
DeAndre Thomas.
Do you know who your lawyer is?
I know her last name is Picklewitz.
Pilkowitz, okay. I haven't seen Miss Pilkowitz yet.
Miss Silver's back.
Good morning, Miss Silver. What can I do for you?
I have 2 exams.
Okay. What time are your exams?
I thought 9 and 10.
All right, you're just a tad bit early.
Well, better early than late.
Absolutely. I appreciate that. Thank you.
Okay.
So, me, you talked about and it about the same thing. When you turn the getting a lot of opportunities. Yeah, I mean, that's what
Good morning, Mr. Brand.
Good morning. How are you today?
Good, sir. What can I do for you?
I have Mr. Vasquez today. It's a PCC that we're going to hold on, and I think it's set for the 18th. So we're going to hold, I think, in person, if
Let
that's
me
what the
call the
court
case.
has. Yep.
Calling case 230-602-6901, the people of the state of Michigan versus Rico Vasquez. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence. Today is the date and time for a probable cause conference. Appearances, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Good morning, Ms. Drain. My name is Neil Brand on behalf of the defendant.
And are you waiving your client's appearance?
No, he should be here. He says he's in the waiting room. It's also under my name. He's sitting in my office. I'm at my other office. He says he's there under Attorney Neil Brand. Is there another person in the waiting room with that?
I have a Rigo Alberto Vasquez Montero.
Yeah.
Okay.
Next time we'll need a Spanish interpreter if we don't have one today, but yeah, that's him.
Okay. Tell me your name for the record, sir.
Rodrigo Alberto Vasquez.
What's your pleasure, Mr. Brand?
We'd like to set this for an in-person exam, and is it still up for the 18th next week?
No, it won't be. I'm going to have to adjust that date. I'm not going to be in on the 18th. Actually, the first available date I'm going to have is January 8th.
All right. May I look at my calendar, please?
Sure.
Let me just into January. January 8th. Yeah, as long as it's in the morning, that's great.
January 8th at 9 o'clock?
Yeah, and that's in person, right? Is that on the 36th side building?
It's 36th District Court, yes, sir.
Okay, I knew for a minute you were over at the other building, so I don't know. I haven't been there in a while.
No, we're back in 36th District.
Okay, January 8th?
January 8th at 9 o'clock.
Okay, I look forward to seeing you. Thank you.
All right, thank you, sir.
Goodbye.
Bond continued.
And we need an interpreter that day.
Okay, Gwen, make a note of that. We need a Spanish interpreter.
Yes, Your Honor.
Okay, am I excused?
Yes, sir. Have a
Thank
good
you.
day.
Have a nice holiday, everyone. Bye, Ms. Drain.
Bye-bye, thanks.
Yes.
Good morning, Mr. Vella.
Good morning, Judge. How are you?
Good. What can I do for you? Oh, you sound like me.
I'm sick at home, so
Did you give me these cooties?
it wasn't me.
I don't know. Start wearing masks when you approach. What can I do for you?
I was told to come on for Marvin Harris Jr.
This is for a PCC?
It was for a competency hearing. I received an email.
I see. Who is his attorney?
I have not received a copy of the competency report on this case myself.
Who is his attorney?
NDS was representing him.
Okay, I don't have anyone from NDS right here right now.
Okay, I'll just hang tight.
Okay. Whew. You should probably take a COVID test.
I'm staying home, so.
Still take a COVID test.
I'm already thinking about it. I did 624 days on one. Yeah, I'm already sending them. I'll be tomorrow. I'll bring out tomorrow. Hey, but I'm at one in the direction of. I don't know, this is the new person we talking about.
All right.
Yeah.
Mr. Quinn.
Yes, Judge,
Good morning,
I'm
sir.
here.
What can I do for you?
I'm here on Mr. McCall.
Okay. Ready on McCall.
Calling case 230-602-7001, the people of the state of Michigan versus Kemo McCall. The defendant is charged with count one, assault with intent to do great bodily harm less than murder or by strangulation. Count two, domestic violence. Today is the date and time set for a probable cause conference. Appearances, please.
Good morning, Your Honor. Sheltering for the people, P number 60249.
Good morning, Judge Christopher Quinn, P69483, appearing on behalf of Mr. McCall.
Mr. McCall, tell us your name for the record.
McCall.
What's your pleasure, Mr. Quinn?
If we could just set this matter for exam, Judge.
Okay, let me ask you this. What's the defendant's bond?
He had a personal bond.
Oh, why is he still in? Waiting on the tether?
You waiting on a tether, correct, Mr. McCall?
Yes. Okay.
Okay. All right. So I assume he'll be getting one soon because I'm going to put this exam date just out a little bit. How is January 8th at 10:15?
That's fine.
At 10:15. Yes, that time works. January 8th, Monday, that works, Judge.
All right, January 8th at 10:15. Bond will be continued.
Okay, thank you.
Thank you.
Thank you.
So I'll be going home today?
Whenever you get your tether.
All right, thank you.
All right. Stay out of trouble.
And then David is already here. Mr. Hayes, that code. More over there. Right that one. Yes, sir. Make that.
So this is how much I've been Wow. You know, they know what to do. They understand when you decide. Yeah, they understand. A whole material. You understand. Can't go to work.
I don't know. Oh, yeah. That's what you crazy. Sure. We were at your you know what? That's true. I know. She. That woman. No. Hours. If I went up and checked in with her, she told me to shut up there. If I didn't check in with her, she said, no, you cut a piece of it. Oh, it was like, so one day I came in. Wrote a little note. So I'm the break. So she's not the hero. No, for God's sake. Only when I got with David, she decided. I had some credibility. Thank you so much for the water.
Okay, we ready on Miss Silver's case? She said she was set for 9 o'clock.
Yeah, let me see if my client's out in the hallway. I don't have a prosecutor here either.
I think Miss Drain is on Zoom.
Okay, let me see if my client's here.
Yes, I'm here, Judge.
How many PCCs do we have left, Gwen?
Just one, Your Honor.
Okay.
Well, I don't have a client. Is he on Zoom?
What's your client's name?
Fareed Davidson calls me all the time. Why would he come to court?
Well, I don't have a Davidson in my waiting room.
All right, I'm going to call him and see what's going on.
Excuse me. What did Miss Silver say her client's name is?
Davidson.
Okay.
No, thank you.
Mr. Davidson.
Here I am for Mr. Davidson. He
He's
thought it
on
was on, yeah, he's on Zoom with a hat on. I don't know if you understand that, but he thought it
Take your hat
was,
off, sir.
he thought it was on Zoom.
I thought it was a Zoom meeting. I apologize, Your Honor.
Take your hat off, sir. Okay, let's call Davidson.
Calling case 230-600-1801, the people of the state of Michigan versus Fareed Davidson. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons of the arm. Count 3, domestic violence. Today's the date and time for examination. Appearances, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Gabby Silver, appearing on behalf of Fareed Davidson.
Mr. Davidson, tell us your name for the record.
Fareed Davidson.
Today is the date and time set for preliminary examination. Are the people ready to proceed?
Your Honor, I do not believe that the complainant has appeared for the hearing today. They were notified of today's date and time for the exam. I cannot proceed without their testimony today.
Motion to dismiss, please.
Do we have security? Do we have a complainant here?
Well, Your Honor.
The court will dismiss this matter without prejudice.
Thank you, Judge.
Thank you, Judge.
Get a dismissal order, Ms. Silver.
Yes, Judge.
All right, thank you.
Your Honor.
Yes.
I was wondering, my weapon was seized during the process. Am I able to receive that back?
Talk to your attorney about it.
Okay.
Thanks a lot.
You're welcome.
I'm all set.
You're all set, sir.
Okay.
What time is Miss Silver's other case scheduled for?
It's scheduled for 10, Judge.
10, okay.
It's a case that's a reissue, dismissed on trial day.
Okay. Who do we have next up?
Edwin Brady.
Miss Brady.
Who is that just walked in?
Yeah, you.
Yes, Madison.
Oh, hey, Madison.
I just kidding. I can't believe you're sick and you had an issue on Friday. It just does not seem like you were very lucky right now.
The issue was actually Sunday.
Oh, sorry, Sunday, but I read the news article, so I was just worried about you.
I'm fine. Thank you. I appreciate that, though. Is that Miss Sprinkle?
Yes, Your Honor.
Is she next?
Hopefully, we were set for 9:15. I understand there are no witnesses.
Okay, let's call Miss Sprinkle's case.
The interpreter, come on. Good morning.
Are we ready on Miss Sprinkle's case?
I'm about to call it right now, Your Honor.
Okay.
We're calling case 230-600-7601. The people of the state of Michigan versus Edwin Brady. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, assault with a dangerous weapon, felonious assault. Count 3, assault with dangerous weapon, felonious assault. Count 4, assault with a dangerous weapon, felonious assault. Count 5, child abuse, 4th degree. Count 6, child abuse, 4th degree. Count 7, domestic violence. Today is the date and time for a preliminary exam. Appearances, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. May it please the court, Carolina Sprinkle, P49898, on behalf of Edwin Brady. Mr. Brady, can you state your name?
Edwin Brady.
Today is the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, I don't believe that we have a complainant present. I do know that the complainant was notified of today's date and time for the hearing. I cannot proceed without their testimony today.
I move for dismissal, Your Honor.
So ordered. The court will dismiss this matter without prejudice. I need a dismissal order, Miss Sprinkle.
I'll prepare that now, Judge.
Thank you. Who's our 9:30?
Michael McCall. Trying to get defendants now.
Mr. Mankin.
Mr. Minkin, okay.
Was in the building, and he wasn't in the courtroom earlier, so he's here.
I'm sorry, I didn't hear you, Beth.
He was in the courtroom earlier, so he's here tonight. Mr.
Okay.
Mankin.
Should I have McCall come up? He's prison.
So what happens?
Yes.
Anybody know McCall? McCall. Defendants, attorney and defendants not here. No, defendants not here. Oh, yeah, attorney here. Any witnesses? Any witnesses? No.
January 17th, 1980.
17.
Yeah.
Let me try to see if Sabria said.
Oh, he needs to get his turn. We can't get it on.
I have to see one more.
See if it's brief. I can call the court officer and see.
I'm gonna ask the judge one question before that. Thank you, though.
Can we give Ms. Pilkowitz a call for Mr. Thomas?
Yes, Your Honor.
Paper.
Okay.
Okay, what's going on with our 9:30?
Wait for the attorney to show back up.
Okay. Any word from Ms. Pilkowitz?
Not yet, Your Honor. Okay, well,
Is there a Levon Cargill on our docket?
no, Your Honor. No, Your Honor.
Okay. Okay, we're ready on Thomas with Ms. Pilkowitz.
Ready. Sorry about that, Judge.
Calling case 230-602-4701, people of the state of Michigan versus DeAndre Thomas, defendant is charged count 1, police officer assaulting, resisting, obstructing. Count 2, domestic violence. The defendant has an habitual court defense notice. Today is the date and time for a probable cause conference. Appearances, please.
Good morning, Your Honor. Shelley Drake for the people, P number 60249.
And good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of DeAndre Thomas. DeAndre, state your name for the judge. I think he's muted in the box. Oh, there he is. You can just wave. All right, great.
DeAndre Thomas. What's your pleasure, Ms. Pilkowitz?
Your Honor, I am requesting digital discovery in this matter. I do believe I've received paper, and I'd just like to set it for an exam.
All right, so what's Mr. Thomas' bond status right now?
Your Honor, he's currently, I believe, at 2,500 cash, but I believe he may have a hold. And so I don't really need to address bond at this time.
Okay, he has a hold. All right. You know what the nature of his hold is?
It's a parole hold, Judge.
Oh, okay. So he won't be going anywhere anyway.
Correct.
All right. The reason I ask is because I'm setting the exams out to January 8th.
I have because the nature of these charges, I guess what I'm trying to say is I'm not confident that he's necessarily going to be violated on parole or that parole will want him. So all of that to say is there any day next week we can squeeze him in for an exam?
Not really.
Okay. I mean, if the court doesn't have availability next week, then we don't have much of a choice.
If I must, I can put him on December 18th. I won't be there to do it, but somebody will.
My only issue is I have to be out in Taylor at 9 a.m. As long as I can do something after 11 anytime, I can make that work.
Or Judge, what about this Friday? Is that too early?
This Friday?
And I've got a 12:15 or a 12:30 and a 12:45 with you Friday, Judge.
You said 12:15 and a 12:30?
I think it's a 12:30 and 12:45. So if we want to set this one for 12:15.
Okay, let's do that then.
Great.
All right, 12:15, December 15th.
Thank you, Judge.
Bond will be continued. Thank you.
Thank you, Judge.
All right,
Thanks,
DeAndre,
thanks,
I'm
Ms.
gonna come see you before Friday, okay?
Okay, thank you.
All right, take care.
You're well, Judge.
Thank you, sir. Mr. Minkin.
Good morning, Your Honor.
Good morning, sir. What can I do for you?
I have an exam on, it's on Michael McCall.
Is your client there?
I think my client's locked up. Oh, he's here? Oh, where is he? Oh, here he is. He's coming out, just now.
Okay, we're ready on McCall.
Calling case 230-601-1501, the people of the state of Michigan versus Michael McCall. Defendant's charges count 1, weapons, firearms discharged in or at a building causing injury. Count 2, weapons, felony firearm. Count 3, assault with a dangerous weapon, felonious assault. Count 4, weapons, felony firearm. Count 5, domestic violence. Today is the date and time set for a preliminary exam. Appearances, please.
Good morning, Your Honor. Shelley Trace for the people, P number 60249.
Good morning, Your Honor. Steve Mankin, P31562. I'm appearing on behalf of Michael McCall Jr.
Tell me your name for the record, sir.
Michael McCall Jr.
Today is the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness was notified of today's date and time for the hearing. She is not present, and I cannot proceed without her testimony today.
Your Honor, I move to dismiss.
So ordered. The court will dismiss this matter without prejudice.
Thank you, Your Honor. Do you need?
Do we have a 945 case?
He was
Who is that on that 945?
That's Ronald Diebel. I'm representing Market.
How you doing, Mr. Diebel?
I'm good. How are you?
Good, sir. Where's your client, Mr. Diebel?
I don't know. I spoke with him yesterday. He said he'd be joining us. I can try and make a quick call, but he's not here yet.
Okay, why don't you do that?
All right, I'll step out.
I don't think I'm gonna get it. Sometimes, once in a while, yes, I haven't gotten rid of it either. Right, if I stand here, you want me to go? I was out. And then they, so they turned down the market. She doesn't want to come in for her. So they said, Mr. Mike, we take this case. Some older attorney. I'm older too. 69. Well, nobody wants it. I read it. Even with it's different. As you said, all coffee.
You needed to verify that, so I called it. So
You got to yell that button first. I had to check the number.
my client and I here.
Oh, okay. Well, that makes sense.
What you got, Mr. Diebel?
I called, it went to voicemail, I left a message. She's aware of a court date. I don't know if the prosecutors are ready to see.
Well, before we get to Z, we got to get to A. He has to be there.
Well, she's not. If you have to KBS some, that's fine.
I'll give him 2 more minutes.
All right.
Thank you. Thank you.
Join us.
Okay, time's up. Let's call Mr. Debo's case. Oh, he's here?
Yes, he made it. Just in
Okay,
time.
great. See, we didn't jump the gun.
No, we did not.
Calling case 230-599-5001, the people of the state of Michigan versus Marcus Buggs. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, weapons, felony, firearm. Count 3, assault with intent to do great bodily harm less than murder or by strangulation. Count 4, weapons, felony, firearm. Count 5, weapons, firearm, discharge from a vehicle. Count 6, weapons, felony, firearm. Count 7, weapons carrying concealed. Count 8, weapons, firearm, possession by a felon. Count 9, weapons, felony, firearm. The defendant has an habitual third offense notice. Today is the date time set for an examination. Appearances, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Ronald Debo, P 63897, on behalf of Marcus Buggs. To my left, please state your name for the record.
Marcus Buggs.
There's a date and time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witnesses were notified of today's date and time for the exam. They are not here, and I cannot proceed without their testimony today.
Your Honor, I'm requesting that this matter be dismissed with prejudice. This is the second time my client's been down here, and it's the second time this has happened. Correct. Am I correct, Mr. Buggs?
Yes.
Well, Mr. Debo, as you know, I can't dismiss it with prejudice in that there's been no adjudication of any fact.
Okay.
So the court will dismiss this matter without prejudice.
Thank you, Your Honor.
Thank you, sir. Good morning, Mr. Noakes. You have to unmute yourself, sir.
Good morning, Your Honor.
What can I do for you?
Well, I was told that you wanted me to zoom in on Marvin Harrison. And Your Honor, I received the report from the Center for Forensic Psychology saying that he was deemed competent. And so I would assume that we're going to have a competency hearing at some point in your courtroom. And I'd like my client to be present.
Let me call the case.
Calling case 230-591-8901, the people of the state of Michigan versus Marvin Harrison. The defendant is charged with count 1, homicide, murder, first degree premeditated. Count 2, weapons, firearm, possession by a felon. Count 3, weapons, felony, firearm. Count 4, home invasion, second degree. Defendant has an habitual offender, fourth offense notice. Today is the date and time set for a competency hearing. Appearances, please.
Good morning, Your Honor. John Vella on behalf of the people, P68673.
Good morning. May it please this honorable court, William Noakes, P42796 of the Neighborhood Defender Service of Detroit. On behalf of Mr. Marvin Harrison, who is not present, I would ask the court to waive his appearance for purposes of this hearing.
The court will waive the defendant's presence. Today is the date and time set for a competency hearing. Our understanding is that we do have a report back from the Forensic Center deeming the defendant competent to stand trial. Mr. Noakes?
Yes, Your Honor. I received that on Friday. I've yet to have an opportunity to review it with Mr. Harrison. I'd like to do that, and I'd like to set a date when we can both be present in court.
So you're not willing to stipulate to those findings as of now?
Your Honor, not without him.
Take your phone. Thank you, sir. All right, no problem. Thank you.
I can set it for a competency hearing December 14th at 8:30.
What day, Your Honor?
This Thursday, December 14th.
That would be fine, Judge.
Judge,
All right.
if we're going to do this in person, is it possible to get a week out at least?
I'm not going to be here next week.
Could I appear via Zoom on Thursday?
Mr. Vella, I have no objection to you appearing via Zoom.
Thank you.
Okay. Feel better, Mr. Vella.
Thank you.
You sound like I feel.
You feel better, Your Honor.
I'm sorry?
You feel better too. Looks like you're
Thank
under
you.
the.
I am. Appreciate
All right.
that.
I will see you on Thursday, the 14th at 8:30.
Thank
Okay,
you.
gentlemen. Have a good day.
Thank you.
You too, Your Honor.
Who's on my 10 o'clock?
I
I hear a voice, but I can't see anyone.
Silver.
Oh, Miss Silver, that's right.
You forgot so quickly.
I'm sick.
I know.
Where's your client?
He's in the lockup, but the prosecutor's not here yet.
Okay.
Okay, thanks. Marcus, out of dismissal?
I was wondering that as well. I think he made that, yes.
Robert? Thank you.
I guess he ran.
I saw him move back, people are often, doing everything they need to do, I guess. Oh, okay, cool, that's fine. And my office will be. Because there's spreadsheet. So we wait until we. Yeah. You can always.
Yes, sir.
I was ready. She said her. She said her.
Okay, come in.
What's your name? Thanks, sir.
Okay, so, she's here again. So you want to hold the exam or do you want to wait? Now hold it again? Okay.
Are we ready on your client, Ms. Silver?
Prosecutor's not here yet, Judge.
Oh, okay.
Start with Elena's.
Yeah, sorry. Let me take that up to server. Get that.
Sure.
Okay.
Sure. Okay, because I copied. Okay. Are you guys on dates?
I still don't have a prosecutor?
But she's on her way over. She was in another hearing.
Okay. Who is she?
Elena Rozek.
Ms. Rosek, okay.
Okay, two witnesses. Just you have witnesses, because there's no reason.
Is our 10:15 here?
No, Your Honor. Okay.
Who's aware on that?
Over. Stand next to you.
No, not with all this. Sorry. Okay, perfect.
Ms. Rozak is there. Okay, are we ready now?
Yes, I believe so, yeah.
Let's call the case.
Calling case 230-599-5301, the people of the state of Michigan versus Cody Sloan. Defendant is charged with count 1, criminal sexual conduct, first degree. Count 2, criminal sexual conduct, first degree. Count 3, criminal sexual conduct, first degree. Today is the date and time set for an examination. Appearances, please.
Good morning, Your Honor. Elena Rozak on behalf of people, P78815. And good morning, Your Honor. Gabby Silver appearing on behalf of Cody Sloan. Before we
There's
begin,
date and time set for preliminary examination. Are we ready to proceed?
yes, Judge, but before we get to the exam, I've got a motion to dismiss I'd like to argue.
Okay.
Judge, in this particular case, the incident that brings us here today is alleged to have occurred back in 2007. In 2008, Mr. Sloan was convicted of another crime and was sent to the Michigan Department of Corrections, where he remains until today. In 2019, there was a CODIS hit for Mr. Sloan on an old rape kit. In March of 2022, the complainant of the case was interviewed, photo lineups were done. In May of 2022, the defendant was visited at the Michigan Department of Corrections by 2 Detroit police officers. At that time, a buffalo swab was taken from him. It was logged into the Michigan State Police. There was a confirmation on September 6th of 2022. So that's already, like 3.5 years after the CODIS hit. On October 11th of 2022, Mr. Sloan was charged with this offense, and a preliminary examination was actually conducted before you on December 14th of 2022. The case was bound over, and Mr. Sloan was given a trial date of November 13th of 2023. At that time, strike that, a few days before the trial date, which we had waited over a year for, the people came into the courtroom and asked the judge handling the case to dismiss the case because they were unprepared to proceed. They did not have all of the witnesses they needed to prove chain of custody for the evidence. At that point, the judge refused to adjourn the trial on the motion of the people. The people moved to dismiss. The matter was in fact dismissed and then reissued. So my motion is first off, I make a motion based on my client's 180-day rule. He has been waiting and waiting and waiting, and the people have done nothing but drag their legs and drag their feet in terms of getting Mr. Sloan to a trial date. And in fact, when the trial date came up, they weren't ready and moved to dismissed and simply used this remedy of docket control of theirs to reissue the warrant. Also, Judge, there are numerous due process violations as a result of the people's conduct in this case. There is evidence that is lost, there are witnesses that are lost, and we have now waited, giving them the benefit of everything since 2019 to be charged and processed on this, 2019 to be charged and processed on this case. And here we are again, starting over. So I ask the court to dismiss this matter.
People?
Your Honor, I will say that I wasn't in a position to be aware that we were doing a motion to dismiss today, based on the 180-day rule, or in, I can't recall what Ms. Silver indicated was her second, but based on the due process violations that are alleged. And so if we're going to make this argument and the court is going to entertain it, I would ask for time to brief the issue and be able to either orally, I don't have to brief it in writing, I could review case law and whatnot, be ready to orally argue it, or we could do actual written motions, whatever the court would prefer. But I'm not in a position at this moment to go through and make the arguments with legal distinction as to the 180-day rule violation, because I know that's very particular and requires certain things. And then also on the due process violations with regard to from 2019 until now. I will also say that I was not the original prosecutor on the case back in 2022 when the case was charged. I was not the original prosecutor that held the preliminary exam. I did not come onto this case until midway through this year after the original prosecutor exited the office, left the office. And when I came onto the case, I did ask the Judge Baker in Third Circuit Court prior to, this was, I think in October or November, right before the trial was scheduled, I asked for an adjournment and the court would not give the adjournment. And the defense counsel did not want to move for the dismiss. The judge said that she couldn't dismiss it unless defense counsel moved. I indicated that the people were not ready based on the out-of-state DNA witnesses that I would have to have. And it was my fault and I fell on the sword for that and asked for the adjournment. If not, I did indicate on the record that I would be reauthorizing immediately, and that is what I did. So the people did move for the dismissal of Third Circuit Court just before the trial. It was on Thursday before the trial was scheduled for Monday, and the people did reauthorize, I believe, the next day or thereafter. And this is how we got here. So just for clarity purposes, but if we're going to argue the actual crux of 180-day rule or due process violations, I would need time to research that.
So far as the 180-day rule goes, my understanding of the 180-day rule is that the people are supposed to make a good faith effort to bring the defendant to trial within that 180 days. It sounds like that they have, and I'm sure there were some things that happened in the interim that prevented that from happening, like COVID-19, which I stand the victim of right now, because I know that hit around March of 2020. The end of February, the beginning of March of 2020. This may be a motion better suited for circuit court as opposed to 36th District Court. I think technically I can entertain the motion at the district court level, but I think it would be better suited for circuit court, and then we'll also give the people an opportunity to brief the issue as well.
I do want to say one thing in response to what the court just said. This is not a COVID-19 issue at all. This case was set for trial back in 2022, set to go on November of 23. And we've been trying.
You said it started in 2019, right?
Yes, Judge.
It didn't get to trial until 2022. That's what I was addressing.
No, Judge, he didn't even get charged until 2022. So those are all separate issues. He got charged in 2022. We did the exam before you in December of 2022, and a trial date was set. So for sure, from that point forward, we have been trying cases like crazy at Frank Murphy. So the issue of their failure, I mean, they waited until 3 days before this matter was to go to trial to decide that they were unprepared to do so. I was ready to go to trial. My client was ready to go to trial. They were not ready to go. Had nothing to do with us. It was them. They came in and said, hey, we know that this matter has been pending a year, but we're not ready.
Excuse me. So I can either entertain the motion now and give the people an opportunity to brief the matter, or we can go ahead and hold the exam, and if it gets bound over, you can preserve your motion and bring it before the circuit court judge if it gets that far.
Judge, I'm going to ask my client, but I'm inclined to have the court hear the motion.
Okay.
My client wishes to have the court hear the motion.
Well, I'm not going to be able to hear it until the week I come back, which will be the week of January 8th. We're talking about even more delay.
It's nothing like the delay caused by the people, Judge. January 8th is a good day for us. Well, no, I'm going to be in a homicide trial. The 9th or the 10th or the
9th
11th.
is fine.
The 11th would be better for the people. I'm starting a trial on the 8th as well.
The 11th is fine.
We're 11th at 8:30.
Thank you, Judge.
Thank you, Your Honor.
I hope to get the briefs at least by the 8th.
Yes, Judge.
Okay, bond will be continued. Thank you.
Thank you.
Thank you.
Is that 10:15 here?
Yeah.
Defendant's not here. Come on.
Come on, front.
Who's my counsel on that?
Humphreys.
James Humphreys. Mr. Humphreys,
Yes.
Good morning. Where's your client?
Hello, Your Honor. I have no explanation for why they are not here.
Okay, let's call it.
Calling case 230-601-3301, the people of the state of Michigan versus Jessica Robart. The defendant charged count 1, weapons, dangerous weapons, using self-defense spray device. Count 2, domestic violence. Today is the date and time set for an examination. Appearance, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. James Humphreys, P 38930 on behalf of the defendant, Mrs. Roberto.
Today is the date and time set for preliminary examination. Are we ready to proceed?
My client is not here, Your Honor, and I have no explanation for her absence.
The court will issue a capious revoked bond and set the new bond at $25,000 cash surety.
Thank you very much, Your Honor.
Thank you, sir.
And Your Honor, for the record, the people were prepared to proceed. We do have a witness present.
Okay. Next case is at 11.
Yes, Your Honor.
No, I
Okay.
10:30. Oh, my
Nobody
apologies.
else.
Are we ready on the 10:30?
Ms. Silver want to know, do you want me to cover for?
Who's our counsel on the 10:30?
Correct. But her, no.
You want me to tell her to come in?
Silver said she'll cover for her husband.
Oh, Mr. Silver? I mean, Mr. Cripps and Miss Silver? That's our.
She said she'll cover for.
Okay. All right.
Anybody? Get better, Your Honor.
I will, thank you. Miss Silver, you're covering for your boss?
I will. I don't know where he is. You know, oh wait, he's calling me. Can I cover for you, boss? Okay, the case is getting dismissed, so whatever. Okay, bye. No, he doesn't think I'm good enough.
Are you serious?
He says I'm in the building right now.
Oh, okay.
No,
He just wants to see me, that's all.
I know, but you know what he does over the years? He'll ask either myself or Sarah to cover something for him. This has been going on for years. And we'll go to cover it and they'll say, oh, he already did it. Like, you can't do this anymore then. You know, we fit it into our, whatever.
He's just so terribly efficient.
Only he could do it. Judge, what are you gonna do? You're losing your court reporter.
I know. Don't remind me.
Oh. Such a bummer.
Don't get me going. I'll start crying.
You're gonna be crying. She's crying tears of joy though.
No.
No, I know. She's just a mainstay. We're so used to
The
seeing
question
her.
is, what is she gonna do? She's been doing this kind of stuff since I was a kid.
Hey.
Yeah. Watch it. She's gonna enjoy life. She's gonna do what the rest of us should be doing. All
I'm
right,
gonna leave
Mr.
her spot open for a while in case she changes her mind.
Cripps has finally showed up, Judge.
On time,
Nah, you're not on time. You're 3 minutes late.
because I was waiting for you to do your 2 exams.
I did that.
Mr. Cripps, good morning, sir.
Morning, Judge. How are you?
Let me get Ms. Strang.
Good. Okay, we're ready on Mr. Cripps' client. And there he goes.
No, he's here.
Here we go.
I just
Okay.
touched my father.
All right.
Miss Dunwoody, Jolise Dunwoody.
We're ready, Madam Clerk.
Okay, calling case 230-601-6601, the people of the state of Michigan versus Jolise Dunwoody. The defendant is charged with count 1, assault with intent to murder. Count 2, weapons, felony firearm. Count 3, assault with intent to great bodily harm, less than murder or by strangulation. Count 4, weapons, felony firearm. Count 5, assault with a dangerous weapon, felonious assault. Count 6, weapons, felony firearm. Count 7, child abuse, 4th degree. Count 8, domestic violence. To date is the date and time set for exam. Appearance complete.
Good morning, Your Honor. Shelley Drake for the people, P number 60249.
And good morning, Judge. David Cripps, P 34972, appearing on behalf of my client, Jolise Dunwoody, who's standing to my left. Tell the judge your name, please.
Jolise Dunwoody.
Today is the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness was notified of the date and time for the exam. These are very serious charges, and if I had any information to give to the court to ask for an adjournment, I would do that, but I don't have any good cause at this time, Your Honor, so I am not able to proceed.
The defense will make a motion to dismiss without prejudice, Your Honor.
So ordered. The court will dismiss this matter without prejudice.
Thank you.
Thank you very much,
Need
Your
a
Honor.
dismissal order, Mr. Cripps.
Yes, Your Honor, I will.
All right, thank you.
Thank you, Judge. Yes. One second.
Oh, okay.
Thank you for getting ready.
Feel better, Judge.
Thank you.
Thank you.
I'll take all of it. You got the paperwork for it.
Sloan, I was working on that.
I'll take it though. I'm gonna just take it all at the same time.
Okay, because it's just something that we this one, but I do have a question.
Thank you.
I'm gonna do this. I'm gonna take notes. Yeah. Yeah, as soon as you get it, I'm gonna go. As soon as you get it set. Do you have to send a copy of the No. Right. Right. So Chris.
Okay, so we're in recess to 11 o'clock.
Judge,
Yes.
the complainants just appeared, for the Jolice, Dunwoody case.
Which one was that? What time was that?
10:30.
Did everybody just leave?
No, everyone's still here.
Oh, okay. We can come back in then.
Okay.
Looks like we get to have some fun after all, huh, Mr. Cripps?
That's right, Judge.
All right. Let's recall Dunwoody.
Recalling case 230-601-6601, the people of the state of Michigan versus Jolisa Dunwoody. Defendant is charged with count 1, assault with intent to murder, count 2, weapons stolen firearm, count 3, assault with intent to great bodily harm, less than murder or by strangulation, count 4, weapons stolen firearm, count 5, assault with a dangerous weapon, belonging as assault, count 6, weapons stolen firearm, count 7, child abuse 4th degree, count 8, domestic violence. Today is the date time for
Appearances for the record, please.
Good morning, Your Honor. Shelley Drake for the people, P number 60249.
And good morning, Judge David Cripps, P 34972, appearing on behalf of Jolice Dunwoody. Tell the judge your name, please.
Jolice Dunwoody.
Today is the date and time set for preliminary examination. Are we ready to proceed now?
Yes, Judge.
How many witnesses for the people?
Just one, Your Honor.
All right. Any preliminary matters before you call your witness?
Your motion to sequester witnesses, Your Honor.
All right, ladies and gentlemen out here in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time. I don't see any other witnesses in the courtroom. Do you have an officer in charge present, Ms. Jane?
No, Judge.
All right. Go ahead and call your witness.
Your Honor, at this time, the people would call Mr. Deontay Lang.
Sir, please give your name and spelling of your name to the young lady seated over there. I can't see him anymore. Can you have him step towards the podium once he does that? Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat all the way up front next to the bench in the witness box. You may begin when you're ready, Ms. Drain.
Thank you. All right, please state your name once again for the record.
Yeah, say Lane.
Okay, Mr. Lane, I'm going to be asking you some questions. If you don't understand something or if you want me to repeat it, please let me know, all right? Okay, thank you. Mr. Lane, I want to bring your attention back to the date of September 25th of this year, 2023. Do you remember that date?
Yes.
Okay, and where were you on that date?
I was at Dunwoody's house.
Okay, you were at Jolie's Dunwoody's house. Is that what you just said?
Yes.
Okay. Judge, can you
Please
hear
speak
okay?
into the microphone, sir.
I was at Jolie's Dunwoody's house.
All right, thank you. And how do you know Jolie's Dunwoody?
She's the mother of my child,
Okay, and how old is your child?
10 years old.
Okay, and do you and Ms. Dunwoody live together?
No, ma'am.
Okay, so a kind of child exchange?
Yes.
Okay, all right. Do you see Jolie's Dunwoody in the courtroom here today?
Yes.
All right, for identification purposes, could you indicate where she is and what she's wearing today?
She's sitting next to the guy next to you on your left side, and she's wearing a white button-up gray sweater over.
All right, thank you. Your Honor, please let this record reflect that this witness has identified the defendant, Jolie's Dunwoody.
So noted.
Thank you. All right, and so you indicated that you were at her house?
Yes.
And that you don't live there?
Correct.
Okay, and what were you doing at her house?
I was bringing my son back to her house that night.
Okay, and how did you get there?
Drove.
Okay, and did you, was anyone else with you other than yourself and your son?
No.
Okay, so what happened when you got there?
Well, I knocked on the door. She didn't answer. I kept knocking. I called. She didn't answer. So I ended up walking around to the side of the house, knocked on the window, and I knocked on the back window first. Didn't get a response. And right before me and my son left, I knocked on the side room window, and that's when she screamed out, you know, "Why don't you go to your own at the house?" And that's when the window broke.
Okay, well, let me stop you. So to your knowledge, was there a plan for you to bring your son over that night?
Yes.
Okay. Okay, you indicated that you said the window broke. Did you break the window?
Yes, ma'am.
And why did you break the window?
I was basically startled when she yelled out so loud. She yelled out like to the top of her lungs, and I was in the process of knocking, and that's when it happened.
Okay. Did you mean to break it?
No.
Okay, so was it an accident? Is that what you're saying?
Objection is deleted, Your Honor.
Sustained.
All right. So after that happened, what happened next?
Me and my son had went to the car. It was like a scary type of situation. You know, I'm like, oh my God, I broke the window, let's go. And me and him got in the car. You know, we drove out of, because I was parked in the driveway. I pulled out of the driveway and turned right, going towards ground. I saw her front door open. So once the door opened, I said, "Hey son, did your mama just open the door?" He said, "I think so."
Objection as to hearsay.
I backed up.
Objection as to hearsay, Your Honor.
Sustained.
All right, so, did you see the door open?
Yes.
Okay, what happened after that?
I backed the car up to the front of the house, but I never pulled back into the driveway
And why did you back the door up? Why did you back the car up?
because I saw the front door open.
Okay, so what were you thinking of was going to happen next?
We were just gonna go in the house. I was gonna apologize for breaking the window, put some tape over it, explain to her that I was going to pay for a whole new window to get installed, and then stay the night like a normal night.
Okay, so when you dropped your child off before, had you stayed the night previously?
Absolutely.
Okay, was that on a regular basis or no?
No, I mean, yeah, it was often. It was often.
Okay. Okay, so that was what you were thinking and that was what your intent was. Is that what you're saying?
Yes.
Okay, so what happened when you backed the car up?
When I backed the car up, me and Joel both hopped out of the car. We ran to the door. As we were running to the door, Jolie screamed out, "Joel, move."
Okay, and where was, and Joel, is it your son?
Yes.
And where was he in relation to you?
He was like right next to me. We was running up the porch.
Okay, and why were you running up the porch?
We was just kept checking to see, you know, make sure the door was open. Like I said, we saw the door open. But like I
Check
said,
as to what somebody else saw, Your Honor, other than himself.
Sustained.
Just say what you saw.
I saw the door open
Okay,
in my periphery.
okay.
We backed up my car up. We both hopped out. We was running to the door. She said, "Joel, move."
Okay. And what happened after that?
I grabbed Joel close to me, like, "What do you mean move?"
Well, what were you thinking?
In my mind, it had to be that she, you know, was gonna try to have a gun or something, but I didn't see her inside the doorway. The door was open. So I did not see her standing inside the doorway at all.
You saw the door open.
Yeah, and I heard her yell out, "Joel, move." I grabbed Joel, like, "What do you mean move?" I had a juice in my hand, I threw it at the door.
You had a juice in your hand,
Mm-hmm.
like a cup?
Is that a yes or no?
Juice.
Judge, I don't know what means.
Okay, you had something in your hand?
Yes,
Okay, and what was it specifically?
it was a juice, some type of juice.
Okay,
In the
like a
store.
bottle?
Yeah, a bottle of juice.
Okay, and so you threw it?
Mhm.
Where did you throw it?
Is that a yes?
At the door.
Your Honor, I'm objecting because we're trying to make a record here.
So you have to answer with words, not mm-hmm or you have to use yes or no, okay?
Okay.
All right.
Thank you.
So you indicated you threw it at the door?
Yes.
And why did you throw it at the door?
I
Okay, and why did you feel angry at that time?
because she knew what was coming over there for her.
Objection, Your Honor, as to what somebody else knew. That would be speculation on his part.
No, the question was not offered for the truth of the matter asserted, but why he felt a certain way. I'll take it for that limited purpose. Overruled. You may proceed.
Before we had got over there, I had pulled up before I picked up Joelle. And I told her I was outside. And she said, "Okay, well, you better have some weed." I said, "I don't have any weed, but I'll go get some when I go get our son." She said, "Okay." I said, "Do you want to ride with me?" She said, "Sure." I sat out there and waited 5 to 10 minutes. She never came outside. So I just called her back and said, "It's okay, I'll just go get it and we'll be right back."
Okay. Then did you leave?
Yes,
And then did you come back with your son?
within 10 minutes, yes.
Okay. Okay, so this is why you were angry.
Mhm.
Okay.
Objection as to leading, Your Honor. There could be a lot of reasons why he's angry.
Sustained.
You testified that you threw the juice bottle because you were angry, is that correct?
Yes,
Okay, and the explanation that you just gave, is that why you were angry at that moment?
yes.
Okay, and so after you threw the juice bottle, what happened after that?
I went up to go grab the door and then I got shot.
Okay, so you go up to, okay, is it like a porch that you have to step onto, or do you just walk right up to the door? Can you describe it?
It's about 5 steps to get on top of the porch where the door is. So like I said, all I did was me and my son were at the porch. She said, Joel, move. I grabbed him and I said, I'm tired of you doing this. I threw the juice at the door and I was like, man, skip this. I just walked up to the door, not thinking that she was going to shoot me.
Okay.
Not even knowing that she had a gun.
Okay.
You know?
So you said you're tired of this. Were you thinking that or did you say that to her?
I said that.
Okay. And so what are you thinking is going to happen at that point?
Like I said, I was gonna go in the house. I was gonna come in the house. Like I said, I was gonna tell her I apologize because I did not mean to break the window at all. I was gonna apologize to her, let her know I was gonna take some tape, cover the hole up in the window, and I was gonna explain to her that I was going to fix the window, get the window replaced.
Okay. All right. And you said you walked up and you tried to open the door?
Yeah, I grabbed the door, yeah.
Okay. So the door was closed at that time or open?
The screen door was closed.
The screen door was closed. Was the regular door, the solid door, was that open?
Yes, that was open.
Okay. And so was it dark or light inside?
It was dark.
Okay. So could you see Ms. Dunwoody at all in there?
No.
Okay. Did you hear her say anything to you?
Yeah, she said, when she said, Joel, move.
Okay. But that's when the two of you were approaching the house, is that right?
We were walking up the stairs, yeah.
Okay, so you two are walking up the stairs. Does she say anything else?
No, not until after the gunshot went off.
Okay, so she never said leave, she never said I'll shoot you, she didn't say anything like that?
No.
Okay. So you're walking up and what specifically happens?
Like I said, we walked up, I grabbed the door, I got shot. Once she shot through the door, I fell to my knee and I grabbed my chest. I said, you shot me? You really shot me? And then she said, yeah, it's over for your ass now, nigga. That was her words. Our son was standing right there. I seen his, he basically jumped out of his body when the shot came through the door. She said, it's over for your ass now, nigga. Joel, get in the house. Joel said, I'm so confused.
Objection as to hearsay.
After he said that.
Objection as to hearsay.
Okay. So without saying what?
I'm sorry, Judge.
Says sustain.
Thank you.
So without stating what your son said, what happened next?
She told Joel to get in the house.
Okay. What did Joel do?
First, all he made was a statement. Then she told him to get in the house again. And that's when he came in the house.
Okay, so he went in the house at that point.
Yeah.
Okay.
The same
Now,
time she said.
you're shot. Where specifically are you shot?
In my chest.
Where in your chest?
Right next to my heart, like an inch away from my heart.
Okay. And what happened next to you?
Well, I got up. I'm just thinking wow, I didn't think she would ever shoot me. You know what I'm saying? I didn't think it was that much of a problem. So what I did was I walked back to my car. I was about to try to drive myself to the hospital. Her neighbor came outside and said, anybody shot? Anybody shot? I said, yeah, I'm shot. He said, do you want me to call the ambulance? I said, please. I walked to the car. I got in the car. I realized I wasn't going to make it.
Why do you say that?
Well, because it was I just felt I was going to fake if I tried to drive away.
Okay, so what did you do after you had gotten in the car and felt this way? What did you do next?
I got back out the car and I went to the sidewalk to the curb. And then I had got down on the floor, on my arm with my elbows to breathe. And then I had ended up taking my shirt off and flipping on my back.
Okay, why did you do that?
Just to get comfortable, try not to panic, things of that nature.
What happened after that?
I know the police walked up to me, they said, who shot you?
Objection as to hearsay, Your Honor.
Okay, the police walked up to you?
Yeah.
Okay, what happened after? Did they ask you a series of questions?
They just asked me, who shot you?
Okay, and did you tell them who shot you?
I just pointed.
You pointed?
Mm-hmm.
What did you?
Was that a yes or no?
You have to say yes or no. So you just pointed?
Yes.
Okay, and what What did you point at?
Her house.
Whose house?
Jody's Dunwoody's house.
All right. And did you ever tell anyone after this event who shot?
Yes.
Who did you tell?
Well, after the situation, I told, what do you mean, that day?
Either that day or any time after?
I mean, I told everybody that Jody was shot.
Okay. And did you receive medical treatment that day?
Yes.
Okay. Did you go to the hospital?
Yes.
What treatment did you receive at the hospital?
They gave me surgery to remove my, they took a piece of my pancreas out.
Objection, Your Honor. He's not a doctor. He can't testify as to what the doctor said. I have no objection to medical records being introduced, but I do object to him
He can
commenting on
testify as to what injuries he sustained as a result of this.
but it would be based on hearsay, Your Honor. What the doctors told.
Overruled. You may proceed.
What injuries did you sustain?
Judge, I object to this because at the probable cause, I requested medical records and I didn't receive them. So now he's going into hearsay as to what doctors told him in medical conditions. I object to the line of question.
Objections noted for the record. Overruled. You may proceed.
What injuries did you sustain, sir?
They removed one of my kidneys. Yeah, I had surgery. I had my stomach cut open. They had to remove a part of my stomach. One of my kidneys and a piece of my pancreas.
Same objection, Your Honor.
How long were you in the hospital for?
8 days.
Do you have to receive any further treatment from here on out? as a result?
Objection to that line of question, Your Honor.
What's the objection?
The objection is I don't have those medical records and I knew this would happen. And that's why I requested him at the probable cause conference. I can't cross-examine as to anything he's saying because I don't have those medical records.
Discovery is ongoing. Your objection once again is noted for the record. Overruled. You may proceed.
Do you have any further, are you planning to have any further treatment or are you required to as a result of your injuries?
No.
Okay, but you don't have to go back to the hospital or doctor at all?
No.
Okay. No further questions at this time.
Jeff?
Sir, could you state your complete name for the record, please?
Yes, Deontay Ramil Lane.
And do you go by any other name, sir?
Yeah, Ted.
Ted Riot?
Yes.
Okay. That's another name you go by?
Yes.
Okay. And within the last 10 years, have you convicted of a felony or misdemeanor involving theft, dishonesty, or false statement?
No, sir.
Now, this location that you went to, your testimony is clear that you did not live there, is that right?
Correct.
And say the only times you could ever go there would be with Ms. Dunwoody's permission, is that right?
Yes.
And in fact, there was a personal protection order taken out by Ms. Dunwoody against you, is that correct?
Correct.
So you knew you weren't supposed to be there according to the personal protection order, is that right, sir?
No.
You just said you were aware of a personal protection order being brought against you.
I was aware of that on October 13th when I found out that I actually had a PPO against me.
Thank you, I appreciate that. So you were violating personal protection.
But I was never served PPO to even know that I had a personal protection order.
That's nice, but you were aware that it existed, isn't that correct, sir?
No, sir.
Well, you just talked about it. You just brought it to my attention. How could you not be aware of it?
On September 25th, I was not aware that I had a personal protection order against me.
So that's your testimony regarding that, is that right?
Yeah.
Now, you've assaulted Ms. Dunwoody in the past, is that correct, sir?
Your Honor, I'm going to object to this line of questioning. This has nothing to do with the reason that we are here today.
It sure is, Judge. That's why she's in fear of this man, because he has physically.
Overruled. Go ahead.
You've assaulted Miss Dunwoody in the past, isn't that correct, sir?
Correct.
Police were called, isn't that right?
Yes.
And how did you assault her in the past?
Arguing.
No, what did you do? Did you physically assault her?
Probably put hands on each other.
I'm asking what you did. You put your hands on her, isn't that right?
Right.
And you used weapons before, isn't that right?
No.
You choked her before, isn't that correct?
No.
And do you have any formal friend of the court permission for drop off of your son to her house? Thank you. Now,
I didn't hear the answer.
could you repeat your answer for the judge?
No.
Now, the day in question, was it during the afternoon that you went over to that location?
I was over there twice that day.
All right, so was it during the
I
day?
left that morning. I came back at like 4 o'clock. I went to go pick up our son. We came right back about 4:10.
Smoking any weed that day?
No.
Drinking any alcohol that day, sir?
No.
And you said that you came by and knocked at that door, is that correct?
Correct.
That was on the front door?
Yes.
And you got no response?
Correct.
So not getting a response to the door, did you leave?
No.
No, you didn't leave. You went to the back of the house, isn't that right?
Correct.
And what was your plan back there, sir?
To get her attention. She don't have a doorbell on her house. So
how are you gonna get her attention?
By knocking on the window. This is something that she's told me to do prior to this.
According to you, even though you had a PPO against you? Is that right, sir?
Yeah, I guess so.
Yeah, so then after not being able to get into the house to the back window, where did you go then?
To the side window.
To the side window, is that right?
Correct.
And you hit that window more than once, isn't that correct?
Yeah, I knocked on the window.
In fact, you hit it so many times you broke that window. Well, did you break it or not?
Yeah, I did break it.
And you were trying to get into that house to assault her, isn't that right, sir?
No, that's not right at all.
Now, you were there to harm her, isn't that correct?
Wrong.
Did you conduct a series of text messages to my client, Ms. Dunwoody, after this incident occurred?
Yes.
Did you say in one of the messages to her, I really apologize if you ever felt like I was gonna harm you that bad?
Yes.
So you said right in that text message that you knew that she felt like you were gonna harm her that bad, isn't that right, sir?
No, I mean, if you look at the whole text message, you're only reading the part of it. If you could read the whole thing.
I'm asking you to comment on that part.
I absolutely did say.
Thank you. So after breaking the side window, where did you go?
That's my vehicle.
All right, so you went to your car to leave, is that right?
Yes.
And then you backed out of the driveway, is that correct?
I actually drove forward out of the driveway.
You drove forward out of the driveway, is that correct?
Correct.
To leave.
Mm-hmm.
Is that a yes?
Yes.
And then you started to go into the street, is that right?
Yes.
And then you saw your opportunity to go after her, isn't that right?
I saw the opportunity of going into the house, but not going after her.
Right. Well, we'll get into that in a second. You saw your opportunity when the door opened, is that right?
No.
You just told the judge you saw the door open.
I did see the door open.
All right. And when you saw the door open, even though you broke the window and trying to get in, you didn't leave, you backed up, is that right?
Correct.
To go after her, isn't that correct?
No, that's not.
Well, you testified that you ran up towards that house, isn't that right?
Correct.
And you ran towards the front door where you saw the door open, is that correct?
Correct.
Did you see her at the time when you're running up to the front door?
No, I did not.
So you claim that even though you said in a text message you didn't mean to harm her that bad, that you broke the window of her house, and when the door opened, you're running towards the house, you weren't there to cause harm to her?
I was not there to cause harm, sir.
That's why you broke the window and charged the front door?
Well, we didn't really charge it. We was jogging towards the front door, and I mean, my son was running right next to me.
I'm asking what you did right now.
I jogged to the front door.
You jogged to the front door, up those front steps, is that right?
Correct.
Grab that front door, is that correct?
Yes, sir.
To get inside without permission at that time, is that correct?
Correct.
And what did you do once you grabbed that door?
Got shot.
Well, what about this bottle you told us about? Forgot about that part. You got a glass bottle in your hand, is that right?
No.
You just told the judge earlier you threw a bottle at that door.
Yeah, but it wasn't glass.
You had a bottle in your hand.
Yeah.
Why did you take it to the front door with you?
There was her juice.
And what did you do with that her juice?
Threw it at the door.
Why did you do that, sir?
Because I was angry.
What were you angry about?
The fact that she knew we were coming back, but she tried to act like she didn't.
So you acted like a man by running towards that door, breaking the window, and then tossing a bottle at that door. Is that right? That's the way you wanted to enter that house that day?
No.
You put her in fear at that time. You understand that?
Your Honor, I would object. I'm asking if there was a question rather than a statement stated to the plaintiff.
You knew you put her in fear, because you said that in your message to her afterward. Isn't that right, sir?
I didn't know I put her in fear.
Aren't you the guy that said, I really apologize if you ever felt like I was gonna harm you that bad?
Absolutely.
So you knew that she felt you were gonna harm her that bad, isn't that correct?
No, that's not correct.
That's what you said in your text message.
The text message came after the shooting.
That's what I'm talking about, your comment on how she felt at the time this happened, isn't that right?
My statement was, I apologize if you ever thought I was gonna hurt you enough to wanna shoot.
That bad, isn't that right? That's what you
That
said.
bad to wanna shoot.
So it's after you threw that bottle at that door, was that door open, by the way? The large
screen door was closed and the large door was open.
All right, and after you threw the bottle, that's when the shot went off, is that right?
No, yeah, once I touched the door. So it was like, I threw the bottle.
Right.
I pulled our son to the side, I walked up the stairs, the rest of the stairs, the extra 2 stairs, grabbed the door with his hand and got shot.
One shot occurred, is that right?
One shot, yeah.
You didn't even see the gun when you were shot, is that correct?
Correct. Only saw the flash.
I'm not gonna ask you a question then. You only saw a flash of what you just said, is that right?
Correct.
And you know she didn't mean to shoot you, isn't that right?
No, I don't know that.
Well, again, we're referring to your post-shooting text messages. Did you say in a text message to her, you probably didn't mean to, but you spoke it into existence? Did you say that?
Yes.
That was a comment upon her and what she did, isn't that correct, sir?
Correct.
Okay. When you got out of that vehicle, what kind of vehicle was it?
Ford Edge.
And when you backed that vehicle up, you left it sitting in the middle of the street with the doors open, is that right?
So the doors weren't open. I did leave it in the middle.
You left in the middle of the street, that's how quick of a hurry you were to get to that door, is that right?
Yes.
Nothing further, Judge.
Any redirect?
Yes, Judge. Now, you said that The date that this happened, you had already been there.
Correct.
Okay, so I believe you said that you had left that morning, is that right?
Right.
So you were at the house that morning?
Yes.
Okay, had you spent the night that night before, or were you just there for another reason?
I spent the night.
Okay, so the night before this, you spent the night?
Correct.
Okay, did she say anything about a PPO? Did the defendant say anything about a PPO?
No.
Okay, and you said, so you left that morning, do you remember about what time you left?
About 6:30.
Okay, and, when did you come back to that house next?
About 4 p.m.
And why did you come back to that house?
Well, because the night before my mom had cooked us some lasagna. And before I had left my mom's house, I asked her to Dunwoody would she like me to bring her some lasagna back. Lasagna chicken and Parmesan bread.
Okay.
She said yes. So I was driving trucks. I didn't take the full week because I knew I couldn't. So I ended up calling her. When I got back to her house, I'm outside calling, knocking, just as I did that night. But Jolise was working from 10 to 6, so her office is upstairs at her house. So I'm knocking. I called one last time on Facebook. She didn't answer, but then she called me right back at 4:04.
Okay.
She opened the door when she called back, and I said, I was just about to leave. She said, you know, I don't have no doorbell, and I was upstairs at work. My phone was downstairs.
Okay.
So I came in the house. Once I came in the house, I said, I'm looking forward to getting to that lasagna. She said, well, it's 4 o'clock. You can go get our son. I said, absolutely. I went around the corner, got our son, came back to the house, back in the driveway like I did that night. When the house, the doors was closed, but they were open. So all we did was reach, open the door, close the doors back. She had our plates open. Our plates was heated up. She went upstairs, went back to work, and ate her lasagna, and me and my son stayed downstairs at the table and ate our lasagna.
Okay, what happened after that?
After we left, after we ate our food, I had went upstairs and I told her, I said, hey, I got a couple moves to shoot, so we'll be back. I told our son to change his clothes. He had on his school clothes from her house.
Okay.
So once I told him to put on these Lions pants she bought.
Okay.
And so he came to the stairs and said, Daddy, is this okay? I said,
But did he get the hearsay again, Judge?
Oh.
And I don't see it.
Okay, so, so your son changes his clothes.
Mm-hmm.
What happens after your son changes his clothes? And not saying what your son said.
I told her that we'll be back. And I told him to grab his book bag. He said, okay. We ended up leaving.
Okay, so who leaves?
Me and Joel.
Okay, and you leave in your vehicle?
Yes.
Okay, where do you go?
To my grandmother's house to drop him off.
Okay, what happens after that?
I went to go donate plasma.
Okay, what happens after that?
Jolise called me. We was having a conversation.
Okay, how long did that conversation last for?
Lasted about 5 minutes because I told her that I needed to make a phone call to see when the guys who were staying in my house was leaving the U-Haul.
Okay.
When I told her I called her back, she hung up. I didn't call back to, go back and forth with her or nothing like that. I just hung up. So then after that, I called my guy. He said, I don't need no.
Objection to hearsay.
Sustained.
Okay. So you made another phone call to someone else?
Yeah.
Okay, and after that phone call, what happened next?
I called his brother. The guy who I called his brother.
All right, so you made another phone call?
Mm-hmm.
Okay, what happened after that phone call?
After that phone call, Jolise had called me back.
Okay, and what happened during that phone call?
She was like, I have a problem with something. And I said, well, what's the problem? And she said, don't worry about it. You're never there to help me anyway. And I'm like, Jolise, what's the problem? She's like, nothing, don't worry about it. So I was like, okay. And we hung up. I hung up from her and I called her about 5 minutes later. And I said, hey, okay, what's the problem? She said, I said, don't worry about it. I said, okay, well, I'll be on my way. She said, okay.
What did you mean when you said, I'll be on my way?
I'll be on my way back to her.
Okay. So what did you do then?
I proceeded to go back to her house, and then I pulled up right where my car was at when me and Joel hopped out. I pulled the car right back in front of her house and said, I'm outside. Her statement was, you better have some weed. I said, I'll go grab some weed when I go grab our son. She said, okay. I left, grabbed the weed, went and grabbed our son, went to the gas station. I got him something to drink, me something to drink, and then some wraps for the weed.
Okay.
And then, like I said, so when I got back to her house, I bagged in the driveway because I didn't think I was coming back out for the night. She don't leave for work before I do. So, like I said, I bagged into the driveway.
Judge, I'd ask for a question and answer.
All right.
Okay.
So let me ask the question first. In your mind, are things okay between you and Jolise
Yes.
or not?
Things were good, cool at that time.
Okay. All right. So you back in the driveway, like you said,
Mhm.
and then what?
And that's when I get out, and then the same thing happened from earlier.
Okay.
I'm calling, knocking on the front door. Knocking, and she never answered.
Okay.
So, I'm sorry.
Okay. And so then what happened is what you testified to before. You left?
So I went around to the side of the house.
Okay. Went around to the side of the house.
Knocked on the bedroom window. I'm like, Jolie, just in case she might have fell asleep, anything of that nature. I'm just knocking, Jolie. She didn't answer. So me and my son about to leave, and I knocked one more time on the side window, Jolie. And that's when she yelled out, why don't you go to your own fucking house?
That's what she said, that's what she yelled out?
Yeah.
Were you surprised when she said that, or what did you think?
I was very surprised.
Okay. And then the window broke,
Yeah.
and then what happened?
I said, me and Joel went to the car. And I got in the car, and then I pulled out to the right. I pulled out that way, going towards wherever. And like I said, once I pulled out, I saw the door open up.
Okay.
I looked at my son, I said, did your mom just open the door?
Okay. And then what do you do with your vehicle?
I put it in reverse, back the car up, and then me and him hopped out. I put it in park, we hopped out the car,
Okay.
and we were both running to the door.
Okay. And you testified that you saw the door open, but not the screen door open.
Yeah, the screen door is open.
Was that surprising to you at all?
No.
Why not?
Well, because sometimes she leave the screen door, like sometimes she'll open the big door or just unlock it sometimes, but it's not really, it's not something that's out of the norm because the screen door was broken. It was broken from a couple of years ago. And sometimes that she'll have it to where the screen door is locked, but you just gotta unlock the door and open it up.
Okay. So you go up there to open the screen door.
Mm-hmm.
Okay, and that's when you get shot.
Yeah.
All right. So just so we have this straight, you spent the night the previous night.
And the night before that.
And the night before that.
Yeah.
Okay. And then you leave and you do come back there that same day. Is that right?
Yeah.
Okay. And then you're having several conversations with her during the day. Is that right?
That's right.
Okay. At any time, did she say, hey, listen, I don't want you to come over today. I don't want you here. Don't come over.
No, not one time.
Okay. And then you said that when you knocked on the window, she said, why don't you go to your own house?
That's not what she said.
Oh,
I
I'm
want
sorry,
you
what
to
did
go to
you-
your own fucking house, please.
Okay. That's what she said.
Yeah.
Okay. And then you leave. Is that right?
Yeah.
And then you see the front door open.
Mm-hmm.
Okay. And then you
Is
stop.
that a yes?
Yes.
And then you back up the car. You and your son get out of the car and you go up to the front door. Is that right?
Yes.
Okay. And does she say anything to you at that point until after your shot?
Correct.
And what does she say?
But she said when we was walking up, all she said was, Joel, move.
Okay, and then you get shot, and what does she say after that?
I said, you really shot me? She said, yeah, and it's over for your ass now, nigga.
Okay. Were you surprised that she said that?
Absolutely.
Okay. Has she ever threatened to shoot you before?
Yes.
When?
Objection, Your Honor. Bringing in prior bad acts here.
Oh, Your Honor, this is very relevant if she has threatened to shoot him before, and now he gets shot.
I don't have any discovery of that, Your Honor. That counts that.
I don't either.
Your legal objection is what?
It's not relevant to this.
Overruled.
Has she ever threatened to shoot you before?
Yes.
When?
Times. One time, she threatened to shoot. I dropped a friend off from work. She threatened to come over there and shoot all of us at his house because I did not come straight back to her house after I got off work. And I may have sat over there and chilled for a minute, but she had my location at the time. And that was the last day I shared my location with her. That she threatened to come over there and shoot me, a co-worker I was with at the time, and his girlfriend.
Okay. All right, so you said she threatened to shoot you several times?
Yes.
Okay. Then I just want to ask you about one other thing. You were asked about text messages between yourself and Jolie after the fact, okay? So what were you trying to communicate after the fact?
Well, when I was in the hospital, the night I got my phone back, I didn't know that she didn't have her phone. And like I said, me and Jolie's been through a lot, but it never really kind of changed, you know, the love we have for each other in my eyes. So like I said, when I texted her and I knew she was home, when I first got my phone, I asked my son, I said, where your mom at? Is she home? What's gonna happen? What we gonna try to do to, you know, get her out of the situation? Because I mean, like I said, at the time, I didn't really, it was still, everything was still, you know, it was like, I was kind of in shock, you know, so I'm like, I still don't want to see her, you know, behind bars and things like that.
You're saying even today, you don't want to see her behind bars?
I mean, I definitely need her to be held accountable for her actions, but, you know, that's still somebody that I, you know, love, you know, so. At the time when our son, he had put his phone on his mom, and I just couldn't bear to look at her, so I put the phone down because she was kind of grooming. Like she was grooming me in the phone when he showed me, he called FaceTime, and I said, "Your mom home?" He put her on the phone. She grooming me. I had to turn the phone off. So later on that night, you know, I was by myself, and I just texted her like, you know, I never thought it would go that far. You know, it never. You know, she pulled the gun out on me multiple times, came around shooting multiple times, but like, I never thought that she would actually want to hurt me or see me hurt that bad, and especially in front of our son, you know, so I didn't, like I said, I was not coming into her house to try to hurt her or anything like that.
Okay, thank you, sir.
Now, you talked about these prior incidents. Did you ever report them to the police?
No, sir.
Never made a single police report?
No.
So we gotta rely just on your word as to whether those really occurred. Is that right?
Absolutely.
And you're the guy who was driving around that on the day in question, saying you're gonna make some move. I'll wait till the consultation's done. Just kind of distracted. No. Could you identify this person from, please, sir? No, I am asking. Yes, I am. Thank you. Could you identify the person in front of us, please?
Detective.
She's the officer in charge of this case. I'm sorry?
No.
What relation is she to the case? Is she a relative of yours?
Yeah.
Well, Judge, she's been consulting with the assistant prosecutor, Shelley Drain, throughout this. I'd ask that she be sequestered.
She's not a witness, is she?
No,
Well, she may be as this develops, I don't know.
she was not a witness.
Not an eyewitness, but she seems to be providing information to Ms. Brand as the case goes on.
I don't see any basis to excuse her.
Okay. You said that you were, on the day in question, you told Ms. Drain that you were shooting some moves. Is that right?
Yeah,
What do you mean by that?
I had to go handle some business.
Was some of the business going to get some weed?
No, not at that time, no.
Well, on that day, did you go get some weed?
After I arrived to our house the second time.
So that day you went to get some weed?
Yeah.
And you took your son with you?
No.
Where did you go to get the weed?
Got the weed first, then I went to go pick him up.
Where did you go to get the weed?
Your Honor, I'm gonna object to the relevance of where he got it from. I don't think that plays any part.
Sustain.
All right, thank you, Judge. So then, you're doing whatever you're doing that day, and eventually you told us that before you went up to that door after you broke the window, you heard Ms. Dunwoody say, "I want you to go to your own fucking house." Is that correct?
No.
You never heard that said, because you testified that earlier.
Yeah, but I actually heard her say it before the window broke.
Okay, well, fine, but it was before you went running up towards the front porch, is that right?
Right.
So you knew that she personally told you that she wanted you to go to your own house, but you didn't listen to her.
She didn't tell me, she asked me.
She said, "I want you to go to your fucking house." Those were her words.
No, it wasn't.
You just testified that way under oath earlier.
She said, "Why won't you go to your own fucking house?"
All right, and you didn't listen to her, did you? No, you drove away, then you saw the door open and saw your chance. Right?
No.
Now, you talked about this screen door being broken to the front door, is that right?
Yes.
You knew it was broken because you had broken it in the past, isn't that correct, sir?
Yes.
You broke it when you tried to break into that house in the past, isn't that right, sir?
No, sir.
Because that's how you knew it was broken. Is that right?
No, that's not.
I have no further questions, Your Honor.
All right, thank you, sir. You may step down. Any other witnesses on behalf of the people?
No further witnesses, Your Honor.
Any witnesses on behalf of the defendant?
No, Your Honor.
People?
Your Honor, at this time I would move to bind over the charge and reserve argument.
Mr. Cripps?
Yes, Judge, we would ask that you dismiss the charges against Ms. Dunwoody. Again, this case revolves around someone who was Mr. Lang, who was told not to be there ultimately. He knew there was a PPO, even though he tries to play clever and say he was never personally served. But he knew about his existence. He comes that day in question, and things may have been fine earlier in the day, according to him, but there came a point in time where they weren't. And I suggest to the court, he knew that he was not wanted at that house and not to come into that house, but he wasn't going to put up with that. This is a man who, by his own admission, had physically assaulted Miss Dunwoody in the past, had broken the front doors to that location in the past, and wasn't going to take no for an answer, even though he didn't live there. So when he came to that house and tried to get in, and eventually, after hitting his hand on the back window of the house, not getting a response, goes to the side window. And he hit that window so many times, so hard, he broke the window. So now we have someone physically assaulting the location. And what kind of message would that be that he's sending to Miss Dunwoody? So he goes, after doing that, he goes to his car and he drives out of the driveway and he begins to leave, but then he sees the front door open. He sees this opportunity then to come back and assault her, which is exactly what he attempts to do, and he gives that impression. Think of this. told by Miss Dunwoody, go to your own fucking house, get out of here. And he knows what her intention is, to leave her alone. He comes back, he sees the opportunity when the door is open. And so he said in his words, he ran towards the front porch. So here's someone's broken the window, now he's coming running towards the front porch and comes up and takes a bottle he has in his hand and throws it at that door. And it's only then, after he runs towards that door, after he's broken the window to her house, after she told him to leave and go away, that he gets shot one time. A person doesn't have to wait till they're assaulted, as they have been in the past, as Ms. Dunwoody has, in order to take actions to protect herself in her own home. And that's what she did, Your Honor. These charges are not warranted in terms of being charged against her. He admits that he made prior messages, post-shooting text messages to her, where he said that he apologized. I really apologize if you ever felt like I was going to harm you that bad. So he knew her mind state, that she was in fear that he was going to harm her that bad. I also said I didn't mean to, but I know you didn't. You probably didn't mean to, but you spoke it into existence. So that also suggests he knew that she didn't mean to do what she actually did, which I suggest to the court is she's simply a person, a homeowner, trying to protect herself from the person who has physically assaulted her in the past. We don't believe, even by his own admission, by those text messages, there's been a showing of a specific intent to kill, for assault with intent to commit murder, or specific intent to cause great bodily harm. She's simply protecting herself at the time he's running toward that porch and begins his assault by opening that door, the one he's broken in the past, and throwing that bottle at her. So we don't believe these assault charges are warranted. A person who's in their own house under Michigan case law has a right, your home, to protect themselves. Your home is your castle. If anyone is intruding your home or breaking into your home, as he did earlier by breaking in the window and then charging towards that front door, she's got a right to take reasonable steps to protect herself. And that's what she did. She shot once, not multiple times, to prevent the assault upon herself. We ask you to dismiss these charges against her. Thank you.
Dre?
Thank you, Judge. Okay, so let's just do a review of what happened earlier. They have a child in common, and the complainant stated that he spent the night there the last 2 nights, and then he left. They had multiple conversations during the day. The complainant went and got food that one of his relatives had made, brought it over. He stated she had the food, he and their son had the food, and then they left. And the plan was for him to come back and bring their son, and he was planning on spending the night again. Okay, so there doesn't seem to be any problems or issues going on at this time until maybe a conversation that they have, and she says, I have a problem with something, but it's okay. Anyway, so he ends up coming back. She asks him to get weed. He goes to get weed. He comes back and he has his son and he's trying to get in the house. And she doesn't answer. He says that he's thinking maybe she's asleep. So he's knocking on the window. She hears him. He hears her then yell. And he knocks so hard that he does break the window. And he says, okay, and then he's ready to leave. So he is leaving. He gets in, and let's just say also, he backed into the driveway, assuming he was going to spend the night, just like he did the previous 2 nights. So he and his son get back in the car, and they are leaving. They pulled out of the driveway, and they're leaving.
Then he sees the front door open. It wasn't open before when he tried to get in, but now it's open. So he backs up. He and his son get out of the vehicle and they are going toward the front door. He said his son was right by him. And what is said? Does the defendant say, you better stop right there or I'm gonna call the police? Does the defendant get out of here now? Does the defendant have her phone and is she calling 911? We don't have any information like that. We don't have any testimony like that. The only thing that the defendant said at that time was to tell her son to move out of the way. So the complainant testified, he's like, what's going on at this time? Still not thinking that he's going to get shot. He does throw a bottle, the bottle of juice that he bought for her, and he tries to open the screen door. Again, the main door is open. He tries to open the screen door, and boom, he gets shot right there. So she had her gun on her. She had her gun ready to go.
Objection line of question. He never saw a gun, so he wouldn't know that.
He was shot in the chest though, so it wasn't with a slingshot. Go ahead.
What? She said she.
It wasn't until he said he touched or reached for that screen door that he's shot one time in the chest. He falls back and he says, I can't believe you shot me. And what does she say to him? You're done now. You're done now. So she knew exactly what she was doing. This actually seems like it was planned out. I'm not gonna let him in the house again, but as soon as he pulls off, I'm gonna open the front door. So he will come up to the door and I'll shoot him there. And that's exactly what she did. He also testified that she has threatened to shoot him in the past as well. So Your Honor, this is not a situation where she was afraid at all. She took the opportunity to shoot him exactly where she wanted him to be, knew that, hey, I'll open the front door, he'll be right there, and I'll shoot him right there, thinking probably that she would get away with it, who knows. But anyway, this is what happened. This is not any kind of self-defense. She didn't call the police. She didn't say, you come one more step and I'm gonna shoot you. You walk in my door one step and I'm gonna shoot you. Nothing like that. Your Honor, I believe that she did try to kill him, and I asked for a bind over on all counts.
Okay, so somewhere in the middle of all this lies the truth. So I have to admit that a lot of what the complaining witness had to say seems somewhat suspect. So you have the complaining witness arriving at the defendant's house with their 10-year-old child. And I'm a little disturbed that all this is taking place in front of their 10-year-old child, that she shoots his father in front of him, the 10-year-old child. But aside from that, he goes to the house and there's some testimony about how he had been there earlier. They had agreed to do certain things. He may have even spent the night. There's also some testimony about a PPO that was not served, but was in effect. Or I guess it's not in effect if it hasn't been served. But I don't know when that PPO came into being. I don't know if it came into being after she shot him and now she's trying to justify her actions. I don't know when that PPO was sought and when it was granted. But in any event, you have the complaining witness coming to the house, knocking at the door, unable to gain entry, then going to the side of the house, the back of the house, knocking on windows, breaking a window, then trying to leave, and then sees the door open, comes back, throws a bottle at the door, and then the defendant allegedly shoots the complaining witness one time in the chest, causing some very significant injuries. So Mr. Cripps, it sounds like, is putting forth an argument for self-defense. But what we know about self-defense is self-defense has to be reasonable self-defense. It has to be commensurate to repel whatever attack that you're undertaking or is being sought against you. Deadly force has to be met with deadly force. The facts as I understand them is that Perhaps they have been in disputes before. Perhaps they had gotten aggressive in the past, physical in the past, whatever the case may be. My long way of saying this is a question of fact to be determined by a trier of fact, whether or not her actions were reasonable or not. Whether she acted in reasonable self-defense by using deadly force on an unarmed man, or at least a man with a bottle at the time, a plastic bottle, because he said the bottle wasn't glass. But in any event, the court finds that people have met their burden of probable cause as it relates to the charges contained in the complaint and warrant. The court finds those charges were committed in the city of Detroit, and the court finds probable cause to believe this defendant committed them. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. Her arraignment on the information, date, and time will be today is the 11th. We won't do it on Christmas. So I think our next date we're open is December 27th. Is that right, Gwen?
One moment, Your Honor.
Or maybe close that day, Wayne Circuit, Your Honor. We asked for a January date.
No, I think we have swing days for arraignments, even on the circuit court side.
I'm not going to be available the 27th.
As you know, Mr. Crip, I don't control the arraignment date. Those are written in stone.
The last day for not in custody arraignments will be Thursday, December 21st. So everybody else would have to be in custody.
I'm sorry? She's not in custody. When is her next arraignment date going to be?
So the next date that they have open is December the 21st. That's their last date. Frank,
And then when? Until when?
the new year, January 2nd.
All right. January 2nd, 2024 at 9:00 a.m. Bond will be continued.
Judge Esteban, my client has posted her family has posted $100,000 10% bond with a GPS tether. We're asking the court to delete the tether condition.
Why?
There's been no contact. She's moved. She doesn't live in the city of Detroit anymore. She has a new living spot that I don't want to put on the court record. She has strong family support here. Her parents are here. She's going to have no contact whatsoever with the complaint. She has a good job at Rocket Mortgage. She has substantial ties to the community.
Ms. Drain?
Thank you, Judge. I'm only asking that the tether remain in place. I'm not asking for any changes in bond at this time. I think the court heard what the complainant had to say as well. But I think that the tether is the least restrictive, especially for the nature of these charges for this case. So I'm asking that the tether remain in place.
As mitigating as these facts are as it relates to the defendant, one could also argue that she had every opportunity to close the door and call the police, as opposed to opening the door and firing a shot in front of her 10-year-old child. But I also recognize the purpose of bond is not for punishment, but we don't want to lose track of the defendant. I don't necessarily conclude that she's a flight risk or necessarily that she's a danger to the community. Is she employed?
Yes, Your Honor. She's employed at Rocket Mortgage for the last 4 years. She's a valuable employee there.
What do you do there?
I'm a data analyst.
Okay. And you've been there for 4 years?
Yes, Judge.
When's the last time you worked there?
Since the incident, I haven't worked since. I'm on leave because I'm been suffering from anxiety and depression since.
Do you have plans to go back?
Yes, sir. I'm scheduled to go back very soon, within the next 2 weeks.
All right. When was this incident?
September 25th, 2023.
When did you get the PPO?
Yeah.
I initially filed one in the second precinct last year in 2022, and since I've put in
When
the
did you
paperwork,
get when did you get this PPO?
November of 2022,
November, so after the shooting?
of 2022, Judge.
2022, Your Honor.
2022. Okay. I'll take the tether off. No contact with the complaining witness, however, you understand?
Yes, Judge.
That by way of you, third party, social media, nothing. Understood?
Yes, Judge.
Okay. Send over a proposed order to that effect, Mr. Cripps.
I will, Your Honor. Thank you very much.
All right, thank you.
Thank you, Your Honor. Have a good day. Hope you're feeling better.
Thank you. You as well. Appreciate that. Hey, what's next, guys? Who do we have next?
One moment, sir.
That looks like Mr. Dozie. Hello there,
Yes,
Mr. Dozie.
Good morning, Judge. We have Mr. Shears. I hope you're feeling better.
You have who?
Walter Shears.
Shears, okay.
I anticipate a dismissal.
15. 12:15.
Yes, it is.
That's gonna be for sure. Yes.
And then we're done. I'll take some.
I just think that is. I mean, it's not.
Just let me know.
Are we ready, Mr. Dozie?
Yes, I'm ready, Judge. More than that.
Where'd my prosecutor go?
I've done that.
Mr. Drain, are we ready on Mr. Gozzi's case?
Yes. Yes, Judge. Yes, Judge.
Okay, go ahead and call it.
Calling case 230-602-0001, the people of the state of Michigan versus Walter Shear. The defendant is charged with count 1, unlawful imprisonment. Count 2, assault with a dangerous weapon, felonious assault. Count 3, weapons, felony firearm. Count 4, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Today is the date and time set for an examination. Appearances, please.
Good morning, Your Honor. Shelley Drink for the people, T number 60249.
And good morning once again, Eric Gozzi on behalf of Mr. Walter Shears.
Walter Shears.
Today is the date and time set for preliminary examination. Are we ready to proceed?
I'm not able to proceed at this time, Your Honor. The complaining witness was notified of today's date and time for the hearing. She is not present. I cannot proceed without her testimony.
Move to dismiss.
So ordered, the court will dismiss this matter without prejudice.
Thank you, Judge.
Thank you, Judge.
Attorney Gozzi, have your P number, please.
6031, sir. Judge, I hope you're feeling better. We'll see you for a probable cause conference on another case. I think it's scheduled to be the 19th, but I hope you'll be in person.
Well, I'll be on vacation during that time, Mr. Gozzi.
Okay. All right. Well, I hope you feel better, Judge. Speedy recovery.
Thank you. Appreciate that. Thank you.
Everybody take it.
Hi, Judge.
Hey, how you doing?
All right.
Who do you have there?
I have Mr. Hicks. We're holding.
Okay.
Sorry.
They have witnesses?
Yeah.
Okay, no
One.
problem.
It shouldn't be long, Judge. I know you're not feeling well. It shouldn't be long.
I'm okay.
Your Honor, I am doing this case. Is it okay if I take 5 minutes to run to the restroom?
Okay.
Thank you.
Thank you.
All right, I need to. I'm doing restroom breaks. I guess I should take my restroom breaks. Run.
Good morning, Your Honor.
Good morning. How you doing?
The question is, how are you, sir?
Just a runny nose and scratchy throat. I'm good.
Drink plenty of fluids. I hope you feel better.
Thank you.
I'm sorry, all right today. Yes, how are you? Just. Okay. You guys have everything you need so far? Yeah, I believe so. Okay. I'm gonna make sure you get it. Yeah, I know that's in person, you know, I want to make sure you get those upstairs. I don't know if this is good, but I just sent one. But I think after that, we're all pretty good for now. You're gonna have two more, which is Tisdale and Walker. They are both jellies. Okay. So if that helps you.
I tried to tell you who your jealous are at the beginning, so I don't know what kind of work you gotta do. But you can prepare yourself.
Thank you.
And I think that's it. So, they're ready on the 12 o'clock as well. On Miss
Okay.
Barry.
Is that a hold?
I'm gonna go check again, because there is a Vic, and I think it's a mine.
How many more days do you have?
Okay. Now, man, you go ahead and stand up. They about to enter to the courtroom, so you can see and each out. Ready, John.
Okay. We can call it.
Calling case 230-601-1701, the people of the state of Michigan versus Albert Hicks. The defendant is charged with count 1, assault with intent to great bodily harm, less than murder or by strangulation. Count 2, domestic violence, aggravated second offense notice. Today's date and time for an examination. Appearances, please.
Good morning, Your Honor. Madison Oro on behalf of the people, requesting permission under MCR 8.120P under the supervision of Attorney Shelley Gray.
Attorney Monica Sanford,
Attorney Monica Sanford, P62315 on behalf of Albert Hicks.
Today's the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, the people are ready to proceed.
How many witnesses for the people?
One witness, Your Honor.
Tell us your name for the record, sir.
Say your name.
Albert Heimer Hicks Jr.
All right, call your witness.
The people call Ms. Kimberly Hubbard to stand.
Give your name and spelling to the court reporter. Okay, stand closer to the podium so I can see you and raise your right hand. Back towards the podium where the prosecutor is. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat in the witness box next to the bench. Keep your voice up nice and loud and speak into that microphone that'll be to your left. You may begin when you're ready.
Thank you, Your Honor. Can you please state your name for the record? Kimberly Hubbard. Thank you. Ms. Hubbard, I want to draw your attention to November 22nd, 2023. Where were you on that day?
At my house, they came to 1 Strathmore Street.
Okay.
Detroit.
So, you just said that's in Detroit. That's in the county of Wayne?
Yes.
Thank you. And did something happen on that date that brings you into court today?
Yes.
What happened on that day?
I was assaulted by Mr. Hicks.
Okay. So you stated, you were assaulted by Mr. Hicks. Is that, Albert Hicks?
Yes.
Okay, and how do you know that person?
He was my partner, and he is the father of my children.
Okay. How long were you guys partners for?
Around 14 years.
And do you see that individual in the courtroom today?
Yes, I do.
Can you please point to him and identify a piece of clothing that he's wearing?
Yes, he has on a black vest.
Thank you. Your Honor, please let the record reflect that the defendant has been identified.
Noted.
So going back to this assault, as you stated, can you just explain to the court in a little bit more detail what occurred?
Well, I worked a 12-hour shift that day. I worked for a before and after school program. So I worked from 6:30 a.m. to 6:30 p.m. I get off of work. I get in the car with Mr. Hicks. He drives me to and from work. I get into the car. I can tell that he's a little upset. So we're talking, and he begins to argue about some things from the past, jobs that he was owed for in the past. So that's how the argument started. I didn't really feed into the argument. I wasn't trying to respond to the argument. It was just kind of, let's just get home. Okay. So we ended up pulling into.
I'm gonna stop you right there. I'm sorry. I just want to ask you a few questions about what you just stated. Okay, so just to clarify, Mr. Hicks picks you up, takes you and picks you up from work.
Correct.
Okay. And on this date, November 22nd, he was picking you up from work?
Correct.
Perfect. And you got into the vehicle with him and you stated there was an argument, right?
Yes.
Okay. And so you were going into a little bit detail, about what the argument was pertaining to. And so can you state that again?
It was about a prior job that he had done. He just told me it was a prior job that he had done that he wasn't properly compensated for.
Okay.
And he said he wasn't properly compensated for it, which I have nothing to do with.
Yeah. Okay, so after he is, expressing these things to you about these different jobs that he hasn't been properly compensated for, what happened next?
He just kept yelling, "Oh, I'm gonna get my money." The job he is referring to, he had done for my current employer. So he felt like I had something to do with that, but I had absolutely nothing to do with that. So I just wouldn't feed into it because that has nothing to do with it.
I understand. So, earlier in your testimony, you stated that Mr. Hicks assaulted you. So at what point did this argument between the two of you turn physical?
Once we got to the residence, which is the Strathmore residence, which I spoke of, we pulled up into the driveway. He got out of the car and he went into the home. I did not go into the house because I did not feel like he was calm enough for us to have a conversation or for us to be in the same house.
Okay, so sorry, I'm so sorry. Just to clarify, so you guys are currently on the drive home while this verbal argument. Perfect. And so you get to the home, and Mr. Hicks parks the vehicle, goes inside, and you stay in the car.
Yes.
Okay, great. And I'm sorry, can you continue back?
I stay in the vehicle. I'm watching movies on my phone. My daughter is sitting in the car with me. She's going back and forth into the house. I asked her to bring me my throw blanket out to the car. I was going to stay in the car. Mr. Hicks continued to come in and out of the house to pursue the argument, but I did not feed into that argument. When he realized I wasn't going to feed into the argument, the last time he walked out, he asked for my keys, and I told him he was not getting my keys.
Just to clarify, Ms. Hubbard, the vehicle that you guys, the keys that you're referring to, they belong to the vehicle that you wanted? Oh, okay, just wanted to clarify.
House keys.
Okay.
House keys. He wanted my house keys, and I told him no. And that's when he pursued to bang on the window. And I would not open my door. I kept my door locked, but he had to set keys to the vehicle. So he unlocked the vehicle and pursued to get in the back seats of that vehicle. And first they started off as verbal, and then when he wasn't getting the responses that he wanted, they turned into a physical attack.
Okay. Ms. Hubbard, when you say physical, was there, when you say physical, can you just explain to the court, what it is, that you mean exactly?
He tried to put pressure on my neck with his wrist. So when he did that, I struggled to breathe. And at some point, I'm not sure when, I was hit in my left eye, and had to receive liquid stitches in my left eye. I'm not sure when that occurred because it was a bunch of me trying to get him off of me.
Commotion, I understand. Okay, so just for the record, you're pointing to your kind of like the flat surface of your wrist, correct?
Yes.
Okay, so kind of where the wrist is. Okay, thank you. And when you say that he was putting his wrist on your, you put your wrist on your neck, correct? Okay. In that moment, did you lose consciousness or anything?
I don't believe I lost consciousness. I just know I struggled to breathe and push him off.
Okay, and sorry, just to back up a little bit, when he was using his wrist, it was just one of his wrists, right?
Yes.
Not both?
Yes.
Okay. And could you feel like you could breathe in that moment?
It was struggle, it was hard. It was restricted.
Okay, so your breathing was restricted. What would you say your vision was like at that
moment? My vision was a little blurry.
Okay.
Everything was happening so fast.
Yeah, I understand that. So what was what was the defendant's demeanor like while all of this was happening?
He was very angry, very.
And was he saying anything while he was doing this?
He did threaten to take my life.
And based on that, Ms. Hubbard, and everything else that you testified to today, how would you describe that you were feeling at that moment?
Afraid. I fear for my life even today.
Okay, just one moment. Okay, no further questions, Your Honor.
Suzanne?
Ms. Hubbard, you indicated that Mr. Hicks had picked you up from work, is that correct?
Yes.
And he was driving you in the vehicle back to the residence where both of you resided at that time, is that correct?
That's right.
And as he was driving back, he was expressing his concern about not being paid appropriately for services rendered for your employer, is that correct?
Yes.
And so you indicated that you did not engage, you didn't have anything to say in response, is that correct?
Yes.
And then you indicated that at some point you arrived at the residence, is that correct?
Correct.
And Mr. Hicks went inside, but you remained in the vehicle, is that correct?
That is correct.
And at some point your daughter noticed that you were in the vehicle, so your daughter came and got in the vehicle with you?
That is correct.
And at some point you asked your daughter to go in and get your blanket or something of that nature, is that correct? And so, at some point you're indicating that Mr. Hicks came back out to the vehicle and was standing at the window yelling at you.
That is correct.
And he asked for your house keys.
That is correct.
But he had entered the house, right? So he had keys to enter the house, correct?
That's correct.
All right, and so your response to his request for the house keys was no, is that?
That is correct.
Okay, and so at some point he unlocked the vehicle.
That is correct.
And he got in the back seat.
That is correct.
Now, what type of vehicle is this?
Town and country van.
Okay, so this is a van, and is it fair to say that you have two individual seats in the front?
Yes.
And are there two individual seats in the back, or is it a bench seat?
It's two individual seats in the middle.
In the middle, okay. And so where was he located?
In the back seat on the driver's side.
So he's in the back seat on the driver's side, and you're in the front seat on the passenger side, is that
That
correct?
is correct.
Okay, and so you indicated that at some point he takes the back of his wrist, if I remember how you wrist, the lower part of his wrist going into where his upper part of his arm is, and he reaches over from the back seat with his back side of his wrist, and he presses on your throat.
Correct.
And from the back seat, from the driver's side, he reaches over to the passenger
He
side.
put his body in between the two front seats.
And so he puts his hand on your throat, is that correct?
That is correct. His wrist.
And his wrist, thank you for correcting me, his wrist on your throat. And at some point, you struggle to breathe, but you never lose consciousness, is that correct?
That is correct.
Now, while he's putting his wrist on your throat, at that point, is he saying anything?
He's saying that I should kill you.
Okay, and so, then you indicated that at some point somehow you ended up with, cut to or laceration to your eye, is that correct?
Yes.
But you don't recall exactly what happened or how that occurred, is that fair to say?
No, I'm not sure how that occurred.
Okay.
It occurred within that moment, but I'm not sure how.
Okay, and so at some point, you get this laceration to your eye, and, at some point, the police are called, and the police arrive, is that fair to say?
That is correct.
Okay, and Mr. Hicks leaves the vehicle, is that fair to say?
Once the police arrive, yes.
Okay, but prior to the police arriving, after you had an incident with your, his wrist on your throat, did that happen before or after the laceration to your eye?
That happened before the laceration.
Okay, so the throat was first, the laceration was second.
That is correct.
And you're confident all of that occurred as a result of Mr. Hicks?
That is correct.
No further questions.
Any redirect?
Just super briefly, Your Honor. Ms. Hodge, I just want to ask you really quickly, did you receive any treatments for your injuries?
Yes, I went to Sunrise Hospital.
Okay, and that was directly after this incident?
Yes, it was.
Okay, no further questions.
Thank you, ma'am. You may step down. Any other witnesses on behalf of the people?
No other witnesses on behalf of the people, Your Honor.
Any witnesses on behalf of the defendant?
No, Your Honor.
People?
Your Honor, at this time we reserve argument and ask the back over as charged.
Counsel?
Your Honor, I understand that there are two counts to this charge. One is an assault with intent to do great bodily harm less than murder or by strangulation. The other is a domestic violence aggravated second offense notice. And I would indicate that at this point, I would argue that the prosecution has not met their burden to establish that there has been the assault with intent to do great bodily harm less than murder, nor by strangulation or a domestic violence aggravated. Miss Hubbard's testimony was he reached from the back seat, put his wrist on her throat. It's hard to see how somebody reaching from the back seat would be able to put their wrist on somebody's throat. Their wrist only, not that his hand grabbed around her throat, not that he put any grip on her throat, but just merely his wrist was on her throat and caused her to struggle to breathe. I don't feel that the testimony rendered by Ms. Hubbard was credible, and I'd ask that case be dismissed.
People?
Yes, Your Honor. So gripping of the neck is not necessarily an element of the statute of strangulation, but what does need to be met in the strangulation to meet those elements, just regard that someone was in fact strangled and that their breathing was somehow affected, whether it was restricted, whether they lost consciousness. And the complainant in this case did state that she, her breathing was restricted, that she did have difficulty breathing. And I think that given, certain size differences as well, it's not necessarily super shocking that someone from the back seat could apply, pressure onto somebody else. But with that being said, we don't necessarily need to prove any sort of full hand grip. We just have to prove, that someone essentially, that someone was strangled or choked and that their breathing was in some way affected by that. So with that being said, we do believe that we have met our burden.
Even more so than that, what's important here is what the defendant's alleged intent is or was at the time that he put his wrist or his hands around the complaining witness's throat. She also indicated that he said when he did that I should kill you. She said that her breathing was restricted as a result, and I didn't find anything inherently incredible about the witness's testimony. As such, the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint and warrant. The court finds those charges were committed in the city of Detroit, and the court finds probable cause to believe this defendant committed them. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date, and time will be January 2nd, 2024 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor.
Judges, two things I want to address before. First, I didn't hear the date of the arraignment. What date did you say, Judge?
January 2nd, 2024.
Okay. Your Honor, it is my understanding that this was Mr. Hicks' home in which this alleged offense occurred. It is my understanding that the alleged victim is no longer at the home. She has left the home. I believe when we had the PCC, she acknowledged that she had left the home. I'm asking that my client be able to return to his home at this time.
And Your Honor, Your Honor, if that's true, the people have no objection to that. However, APA Shelley Drain did just go ask the complaining witness if that is in fact true.
Okay, give us a second. We'll verify that.
Okay, and the other issue is when I was at the PCC, I asked for my client to be able to be go to work Monday through the weekend, actually 6 to 6. The court agreed to 6 to 5 Monday through Friday. That prohibits him from working on Saturdays and Sundays while he's doing his home repair work. He's asking to be able to do home repair work on the weekend as well.
Okay, Judge, we have an update. The complaining witness in this case, did state that all of her belongings are in this home. So if she could just have 72 hours to just retrieve her mail and some of, her belongings, then yes, we would have no objection to the defendant staying there for 50 days.
Counsel, you okay with that?
72 hours is fair for her to get her things.
Okay. Send over a proposed order to that effect. As it relates to him working on the weekends, he's doing what? Home improvement.
Yeah, he has his own business, Your Honor. I had addressed this at the probable cause conference, and you had given him 6 a.m. to 5 p.m. Monday through Friday, but sometimes he's doing home repair on the weekends as well when he's trying to finish up a job, and so he's not able to go on the weekends because you only gave him Monday through Friday.
People?
Your Honor, people don't have any objection if he's trying to get to work.
All right. Give me an order to that effect as well.
Okay, thank you, Your Honor. I'll send it over.
All right, thank you.
If I don't see you anymore, enjoy your holidays.
Thank you, same to you. Okay, who's next?
Right here.
Good afternoon.
Good afternoon, Judge. Right here, Mr.
Hey, we're ready on Miss Barrett's case.
Calling case 230-600-7201, the people of the state of Michigan versus Lamonte Richardson. The defendant is charged with count 1, criminal sexual conduct 3rd degree. Count 2, criminal sexual conduct 3rd degree. 3, controlled substance delivery of marijuana to a minor. Count 4, assault or assault and battery. Today is the date and time for examination. Appearances, please.
Good afternoon, Your Honor. Tina Ripley on behalf of the people, P83688.
Good afternoon, Judge. Melita Barrett on behalf of Lamonte Richardson, P43238. Tell the judge your name.
Lamonte Richardson. Today is the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, unfortunately, at this time, the people are unable to proceed.
Judge, based on that, we make a motion that the matter is legally dismissed.
Why aren't the people ready to proceed?
Judge, the complaining witness is not ready to testify at this time.
The court will dismiss this matter without prejudice.
Thank you, Judge.
All right, thank you, Judge. Judge, I want to see you in person.
You don't want to see me in person. I got COVID.
Oh, yeah, but I see your contraband in the courtroom. You know, I got to talk. I see your contraband in here, and you know I got to say go blue. You know I got to say that.
Don't stop us, man. I still have contempt powers from even on Zoom.
All right,
I can go over there and see.
I heard you was not ready for that.
Roll Tide, roll.
All right, I see if I don't see you, you can have it.
They gotta take it up.
Texting somebody?
I'm about to see
They gotta take it upstairs to be signed.
Oh,
So you just gotta wait till it gets signed. And when it gets signed, you just gotta go upstairs. So you just want to sit? Yeah, we just need to sit. All right, have a good
Who's across? See who's up. Who's next?
1:30, Judge.
1:30? Okay, we're down to 1:30.
That continued homicide, says.
What is it?
Held in current continued homicide with Mr. Hart. Tisdale, Aaron Tisdale.
Oh, okay. That witness was supposed to be appointing a counsel, an attorney.
He's not over there. We have that's a judge, but I'm gonna take.
Judge, let's take it to 1:30.
Okay. Court is in recess to 1:30.
You know, you got the hell in the park, right?
Yes.
You gotta know.
Yeah.
Yeah. But she gonna come in, but. You can, leave it on out, she gonna come in. Okay. That one dismissal, do you need me to take it upstairs? Signature. Okay, so they said Judge Brady is left. Okay, let me see if Judge Jefferson signed. All right, there's an order for dismissal, and there's one binder over, and she signed that one. Okay. All right, thank you.
Your Honor.
Yeah.
So Sabrina's gone. Let's see if Jefferson is available. Giles is gone. If not, is it okay to take it to Jones or somebody else, or what would you want me to do?
Take what?
The file to be signed off on, the dismissal and the Hicks case.
Oh, yeah, that's fine. It doesn't matter.
Okay, I just want to make sure it's okay. I'll be right back.
Okay.
I can try. Yeah, that might not. Find something to get a title for it. I know it does. What they're saying is but I will make a note.
All right, Madam Clerk.
She was here.
Judge Jefferson.
Okay. What time she say?
She might be leaving shortly, but we'll get you somebody.
Well, I mean, I guess it's not, it won't be terrible, you know.
No.
They're all the customers, not like they do now, right?
Right.
So.
Yeah, that young man, he just waiting on this dismissal. Make sure she signed that one. Oh, yeah. I know she said she signed it.
Slow, this is slow.
Okay.
Take it back to that one back to her.
I'm on my lunch now, y'all.
Oh, no, I feel you. I'm supposed to be on my lunch too, but I'm if she,
I got you.
I can see if it's Judge maybe Williams.
Gotta be careful my steps, young lady. I'm sorry.
Thank you.
And I get his copies on.
Yes, these are all his, or his councils, if they're still out there. All right. Enjoy your lunch.
I will do you likewise, honey.
I'm so tired. And there's my phone. Woohoo! It's still here.
That thing about, I think for like, well, sitting up out here, go sit on campus, I got some notes to go.
Okay.
Try to do a quick,
What up, though?
Judge, what's going on? How you doing?
I've been better. How about yourself?
Good, I heard you're under the weather, man. Get better, all right? It's too close to the end of the season, you know?
I know. I guess I'd rather catch it now than during my vacation or during Christmas.
Right, exactly. You going anywhere?
Staycation.
Ain't mad at that. You know, I feel hook up with your nephew, David. Do some ballroom with him.
Oh, okay. That's my cousin, first cousin.
Yeah, okay, yeah. Well, we been kicking. I'm supposed to hook up with him pretty soon.
Yeah, he pretty good.
Yeah, he cool. He cool beat. Yeah, he
Yes,
cool.
sir.
All right, Ms. Rudder, I'm out.
All right, have a good one.
Do the same, Judge.
You too. Hey, Miss Gwen.
Hey, Your Honor, how are you? Well, we all know how you doing.
I hear you.
Making mistakes down here.
Say what now?
You hear me down here making mistakes?
Nah, you ain't making no mistakes.
Thank you. I appreciate it.
Don't even try it. Who's the young lady just walked in the courtroom with her back to me?
Attorney Damon Brady, Your Honor, good afternoon.
Hey, what's going on, Mr. Mike Grady?
Not much, I'm sorry you're sick. Hope you get better quick.
Thank you, I appreciate that. You have something with me this afternoon?
Yes, Clifton Walker
Okay.
is 3 cases set for exam.
Oh, joy. Okay.
Which case they gonna call first so I can call the prisoner? You know which one?
Say that.
I said both of these are detained. Walker and Tisdale. You know which one they gonna do first? Both of them at 1:30.
I guess it depends on who's already first.
Right. I'm gonna call them up until.
Hello there, Madam Prosecutor.
Oh, Judge.
Over here.
Hi, Judge.
Hi, how are you?
Good, how are you?
Oh, okay.
I've been better, but I'm surviving.
Oh, no.
Just when I thought I was Superman and could never catch COVID, here I am.
Oh, no. Took you 3 years.
I know, right? Here I am. I've been exposed to it by just about everybody and never caught it.
Yeah, and I've had a couple close calls in here myself.
Oh, okay.
Somebody got me.
Okay.
Are you holding on both? Are you prosecuting both of them? Or?
No, I'm just on Aaron Tisdale.
Okay.
How many cases do I have this afternoon?
You got, well, that one guy got 3 cases, and then you got this Tisdale case.
Okay, the Tisdale is the held in part.
Yeah.
Did we get an attorney for that witness?
Yes.
Mr. Slough? Okay. All right. I wonder if she's gonna hold on all 3 cases.
They talking now, I'll find out in 1 minute.
Okay, who is that I'm talking to?
Pen?
Who is it?
Pen. Can you see?
Oh, okay. Oh, there he is. Okay, gotcha. Uh-oh. Excuse me. Excuse me.
Oh, well, then, great, there's our answer. Thank you.
Is he going? It was a turn. Okay, all right.
Are we ready now?
Yes, Ron. What's the date, bro?
26:59.
Okay, let's call the next case.
Oh, got three, but.
Which case are we going to proceed on first? People?
Your Honor,
Which,
the first case that we're gonna proceed on is case number 230-600-7101.
6007.
Calling case 23060070101. The people of the state of Michigan versus Clifton Walker. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence, second offense notice. Today is the date and time for a examination. Appearances, please.
Good morning, Your Honor, or good afternoon, Your Honor. Madison Oral on behalf of the people pursuant to NCR 8.120B, requesting permission under the supervision of Attorney Shelley Green.
Permission granted.
Good afternoon, Neighborhood Defender Service by Kate Damon Brady, P83667, on behalf of Mr. Clifton Walker, who's present with us here in the courtroom. Mr. Walker, will you please state your name for the court?
Clifton Bernard Walker.
There's a date and time set for preliminary examination. Are we ready to proceed?
The people are ready to proceed, Your Honor.
Defense is ready. We would just move for a mutual order of sequestration.
How many witnesses for the people?
One witness.
Ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time. All right, call your witness.
At this time, the people call Latasha Gates to the stand.
Please step forward, give your name and the spelling of your name to the young lady that's seated to your right. step back towards the podium for me?
1 minute, Judge.
Okay. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat in the witness box right next to the bench. Keep your voice up nice and loud and speak into that microphone that'll be to your left. You may begin when you're ready.
Thank you. Can you please state your name for the record?
Latasha Hayes.
Ms. Hayes, I want to draw your attention to October 7th, 2023. Where were you on that day?
I was at the apartment in 2258 West Boulevard.
Okay, and that's in the city of Detroit,
Yes.
county of Wayne?
Excuse me?
It's in Wayne County?
Yes.
Thank you. And who does that address belong to? Is it a home, an apartment? Is it yours?
It's an apartment.
Okay, and is it your apartment or someone else's?
No, it's my significant other, but I was there with her on and on.
Okay, and who is your significant other?
Clifton Walker.
How long were you in a relationship with Mr. Walker for?
Almost 18 years.
Okay, and do you see Mr. Walker in the courtroom today?
Yes.
Can you please point to him and identify a piece of clothing that he's wearing?
Yes, he's to the right of his attorney with the Wayne County jumpsuit.
Your Honor, please let the record reflect that the defendant has been identified.
So noted.
Thank you. And so, did something happen on this date that brings you into court today?
Yes.
And what happened on that day?
I got into an argument with Mr. Walker to where he pulled out 2 knives on me, tried to stab me, so I called the police.
Okay, so just to back up a little bit, so you stated that you were at this address with Mr. Walker and you guys got into an argument. Did the argument start as a verbal argument?
Yes.
Okay, and eventually it turned physical, correct?
Objection leading.
Well, Your Honor, she just testified. Okay.
Don't leave.
So at some point, did the conversation was it no longer a verbal conversation?
Yes.
Okay, can you please explain what happened next to the court after this verbal conversation?
Well, he woke me up to the argument.
I'm sorry, can you repeat
He
that?
woke me up to the argument, basically accused me of some things that I didn't do, to where he put his hands on me and I left. He told me to go get my medicine from the pharmacy, but I left and went downstairs to go. When I came back to the apartment to talk to him, he came at me with 2 knives and told me, bitch, get out of my house.
Okay, so just to clarify, you were sleeping,
Yes.
and then you were woken up by an argument, correct?
Yes.
Okay, and so that's again how this verbal argument is what you were woken up to.
Yes.
And at some point, when you were kind of still waking up, you then realized he had 2 knives with him? Is that what I'm just clarifying? Did you?
Objection, mischaracterization of testimony.
Your Honor, I'll be straight.
Clear that up.
I'm sorry, can you just state a little bit as to what happened? You stated that you woke up and you were in this verbal argument. What happened next?
He was accused me of some things I didn't do, and I was still just waking up to where Mr. Walker was arguing with me. He told me to get out of his apartment. That was the beginning part.
Okay, and so can you explain a little bit to the court? You're stating that he had 2 knives with him. Can you explain?
Yes.
Can you explain what those knives looked like to the court? Were they black?
It was brown with a silver metal piece. It was 2 of them from the kitchen.
Okay, so would you?
I don't know. I came into the house to talk to him, but I was downstairs. He got mad at me, called me beef and pushing me, and he came at me with 2 knives. So I had to call the police.
Okay, and so you stated those knives were from the kitchen, so
Yes.
would you describe those knives as like butcher knives? Or I'm just trying to clarify, exactly what type of weapon. So, you're stating that, again, they were knives from the kitchen. So were they like butcher knives, smaller, larger?
A little smaller, a little long.
Okay, thank you. Your Honor, can I have one moment, please?
Okay.
Ms. Hayes, and so when he has these two knives in his hand, can you explain what he was saying or doing while he had these knives in his hand?
He was cursing at me, he pushed me, I was trying to talk, I was trying to talk to you, he said, what you here for? You told me to come back to the apartment, so he got mad, and I ended up calling the police.
Okay, so, just to clarify, he told you to come back to the apartment?
Yes.
Okay, and so you were.
But I was cold, I didn't have a cold, and I wanted to talk to him, because he was mad at me. I was trying to figure out why he was mad at me, trying to get a resolution where everything would be okay, and I was good to stay in the apartment until I felt like going back to my sister.
I understand. So when, he came up to you with these two knives, what was his demeanor like in that moment?
He was mad, called me on my name, called me bitch, he pushed me.
And how did you feel in that moment?
Scared, so I ran and called the police.
And I just want to clarify, I'm sorry, one more time. You stated that I asked you what he was saying when he had the knives in his hand, and you stated that he was telling you to leave? Is that what
He
you
called me
stated?
on my name, he pushed me, told me to get out of the apartment.
Okay, okay. All right, no further questions now.
Cross-exam?
Yes, Your Honor, one moment. Good afternoon, Ms. Hayes.
Good afternoon.
I'm gonna ask you some questions. If you don't understand a question or it's confusing, you can just let me know and I'll ask a better question. Is that fair?
Yes.
So back on October 7th, you said you were sleeping.
Yes.
When you woke up to an argument, is that right?
Yes.
And where were you sleeping?
I was in the bed, Mr. Walker.
Okay. And I've never been to this apartment before, so how many bedrooms are there in the apartment?
One.
One bedroom. Can you describe the layout of the apartment?
You walk in the door, it's the dresser to the right, and it's a big table. He had windows, you go in the back, so it's from the bathroom, closet, and then it's the bedroom.
And is there also some kind of kitchen area in
Yes,
this?
the kitchen.
Okay, and what room is the kitchen off of?
The dining room.
And is it that front door opens up into the dining room area?
Excuse me?
Does that front door into the apartment open into the dining room area?
Yes.
So off of the dining room, there's a bedroom.
It's like the bathroom in the bedroom.
Okay, so off the dining room, there's a bathroom.
Yeah.
And then there's a bedroom.
There's a closet in the bedroom.
Okay, and then there's a kitchen, which is a separate room off of the dining area.
Yes.
So you wake up in the bedroom.
Yes.
And then you said that Mr. Walker told you to go to the pharmacy.
He was already arguing with me. I said he accused me of having someone in the house.
Okay.
And then he told me to go to the pharmacy.
And then you testified on direct earlier that you went to the pharmacy.
No.
So you did not go to the pharmacy that day?
No.
You mentioned that you went downstairs though. You testified earlier you left the apartment, went downstairs, and that you were cold. So you did not testify to that?
No, I never said I went downstairs.
Did you leave the apartment and then you came back?
Yeah, I did.
Okay, so when you left the apartment, where did you go?
I went downstairs, straight back upstairs.
Great, so when you say downstairs, this apartment Mr. Walker's apartment is on the 4th floor, correct?
Yes.
So when you say downstairs, where did you go downstairs?
A friend.
To which floor?
First.
Which apartment number?
I don't know the number. I'm finished.
What's the person's name?
His name is Will.
Will? Does Will have a last name?
I don't know his last name.
Okay. So you go down to Will's apartment, and then you came back upstairs because you were cold.
I wanted to talk to Mr. Walker.
You wanted to talk to Mr. Walker?
Yeah.
So you
he
said.
never told me that I'd have to come back right in there.
He never told me until when I came back that I couldn't come back in the apartment.
You're saying he never told you you couldn't come back, so that's why you went back?
Yes.
And, you also mentioned on the record that Mr. Walker told you to come back.
Yes.
How did Mr. Walker tell you to come back?
He told me to go get your medicine and bring that money back. Or don't come back without it. But he told me to bring the money back.
And by him saying, go get your medicines, did you understand that to mean to go to the pharmacy?
Yeah.
And you did not go to the pharmacy?
No.
So you come back into the apartment and you enter back into the dining room area through the front door.
I didn't get all the way in the apartment. When he came at me with the knife and pushed me off in the hallway.
In the hallway of the apartment?
Yes.
So describe for me exactly where in the hallway this happened.
Right at the beginning of the door.
So you approach the door. Do you knock on the door?
I came in with the code. I hit the code.
You have the code to the apartment door. It's a 404 apartment?
Yeah, 403.
403. So it's apartment number 403, and you have the code, right?
Yes.
So you punch in the code.
Yes.
And you open the door.
Yes.
And you step into the apartment.
I didn't get in the apartment. I got ready to step in. He pushed me. He came at me with two knives from the kitchen.
Okay. So when you say he pushed you, what part of his body touched your body?
His hands.
His hands touched your body?
Yes.
Both of his hands?
Yes.
Okay, and did they touch your arm, your chest, what are we
My
talking
chest.
about? Okay, and they pushed you backwards?
Yes.
Okay, and fair to say you then took a step back out of the apartment?
Of course.
I'm sorry, you said?
Of course.
Okay, and the door closes?
No.
Okay, so Mr. Walker keeps coming?
Yes, he came at me with the knife. I had my backup phone, but he took my other phone, and I called the police.
So where were you when you called the police?
In the hallway.
And, what were you wearing?
I don't remember.
Okay, what was Mr. Walker wearing?
I don't remember.
Okay, what time of day was this?
Excuse me?
What kind of time of day was this?
I didn't get the time. I had no phone. I don't know exactly what time.
I thought you had your minute phone on you.
I had a phone that I can call emergency on. I didn't look at the time. He was coming at me, arguing with me, and you coming at me with me, but now I'm not about to take on no time. I'm gonna take on 911. You coming at me, you in danger of my life. So that was the first step.
Understood. Had you taken your medications that day?
I'm not off any meds. I was going to get my new prescription. It was my pain meds, a whole bunch of other stuff, which was stolen eventually.
So had you taken your pain meds that day?
No.
Had you taken any other medication that day?
No.
Had you had anything to drink that day?
No.
Had you smoked any marijuana that day?
No.
Had you smoked any crack cocaine that day?
No, I didn't.
So, Mr. Walker pushes you with both hands on your chest.
Yes.
At the door. How many did you take a step back, 2 steps back when he pushed you?
I stepped back.
And did you ever lose sight of Mr. Walker? So at the door, when he pushes you,
No.
does he ever go back into the apartment?
No.
The police responded that day.
Yes.
And you told them everything that had just happened.
Yes.
You told them about the 2 knives.
Yes.
And you told them, straight that. Are there any other details? Did you testify to everything today that happened?
Yes.
Just one moment, Your Honor. So at the door, when Mr. Walker, right, you testified, he pushed you with both hands and then you took a step back. Is that fair?
Yes.
And that he didn't go back inside the apartment?
No.
So where did these knives come from?
He had them when I opened the door. Ask Mr. Walker.
So Mr. Walker pushed you with his hands. What was it? Were his hands open or closed when he pushed you?
They're open. He had them knives. I don't know, you know, in his shirt or whatever, he had hurt shirt. I don't know, he came at me with them.
Okay. So you're testifying when he pushed you, he didn't have anything in his hands?
He pushed me, but he had the knife. He already had the knife, and I opened the door.
Right, you thought that they were, you just said they might have been in his shirt or in his pocket, right?
He took them out of one, that's all I know. He shouldn't have it, for what reason did he have the knife? Well, pushing me, you need to ask him that.
I understand that.
You want to come back in the apartment.
If you can just listen to my question though. So you just testified that when he pushed you, that the knives were maybe in his shirt, you don't know if they were somewhere on him, you think?
Yes.
And that his hands were open?
Yes.
And that there was nothing in his hands at that moment when he first pushed you?
No.
No, there was nothing in his hands? There was nothing in his hands, correct?
I just answered that.
Okay, as in, you answered it to say there was nothing in his hands, right?
Yes.
Thank you. So, at what point did he produce these knives?
It's like right after he pushed me, he had the knife, called me, just told me to help on the top.
Okay. And where did he get the knives from?
The only knife that we have in our apartment that we usually get in our apartment is be in the kitchen room. But I don't know when I first came in, got ready to come into the apartment, like, I didn't see him go get it, so I seen him when he came at me.
Did you see him take the knives out of his pocket?
Yes, he had him in his hand, and came at me.
Did you, so you saw it, which pocket did you take them out of?
Yeah, I don't remember the button up shirt he had on, coat, this brown coat.
You had on a brown coat?
Yes.
Okay, and which pocket did he take the knives out of?
I'm not sure, but I know he grabbed them out, like really fast, it happened really fast.
So, you don't know where he got the knives?
The only place we have the knives is in the kitchen, so we had to get it from the kitchen.
I mean, from his person, right? Because you said he didn't go back inside. So where were they on his body when he then had them in his hands?
I saw him in his hands.
So are you testifying you don't know where they came from on his person?
That I know he came there with me with.
Just one moment, Your Honor.
Okay.
So Mr. Walker, your testifying had on a button down and a brown coat?
Yes.
So he's coming from the bedroom with a coat on?
I don't know where he came from, like I said, when I got ready to come to the apartment. I don't know if he's in his room or not. I know when I opened the door, he was right there. I don't know if he's in the apartment or before, by the time I came up there, no. I wasn't upstairs.
And it's true that Mr. Walker had asked you to leave the apartment, correct?
That's the question we did.
And he told you you couldn't stay there anymore?
No, he didn't.
All right, nothing further, Your Honor.
Any redirect?
No redirect, Your Honor.
Ma'am, you said that the defendant came at you with two live knives. What do you mean came at you? Explain that to me.
I was coming into the door and he saw me. He saw who it was. And I was telling him I was trying to talk to him because he asked me, why am I back up there? And I told him I was trying to talk to him because he was mad at me. And that's when he pushed me and he came to me 2 knives and called me B.I. She said, it's F.O. Go get my field stuff and promise.
How was he holding the knives when he came at you?
When he grabbed the knife, he had him in his hand and he charged that.
All right. And how did that make you feel?
I was scared to where I called the police. He came out the building coming at me and I was still on the phone with the police in the hallway.
Any questions based on my questions?
No.
None from the people, Your Honor. Just briefly, you said he grabbed the knives. Where did he grab the knives from?
It had to be on. He came quick to me with the knife.
Did he have, so he has 2, you're saying that there were 2 knives?
Yes.
And describe what they look like.
Round handle and silver bone metal piece.
And did he have these 2 knives one in each hand, one in both hands?
Yes, it is.
Which one is it?
Both of them.
So he had one knife in each hand?
Yes, he did.
One in his right hand and one in his left hand?
Yes, he did.
Earlier, when the judge was asking you some questions, you held up one hand with, as if you had two knives in one hand.
No,
No, that's not correct?
no, I didn't even put my hand up, with that call.
So your testimony is that he, after he pushed you with two open hands, he grabbed two knives from somewhere and had one in each hand.
Yes, he did.
And this is all happening in the hallway of your apartment building.
It's like right across from this is the door and I'm right here.
So you're outside of the apartment, correct? You're in the hallway of your apartment.
Yes, he came off behind me.
Right, so you're in the hallway, you're not actually inside the apartment.
No, he pushed me.
Were there there's other apartments on this floor, correct?
Yeah.
Were there any other neighbors out in the hallway?
She don't want to come out the neighborhood parking lot. She don't want to come on.
Was she out in the hallway?
No, no.
Okay, was there anyone else in the hallway?
Not at that moment.
Well, you were on the phone with the police. Or is there anyone else in the hallway?
No.
Did you see anyone else in the hallway throughout the whole interaction?
Not when that happened, no.
So the only other person you spoke with in the building during this interaction is Willie on the first floor.
Yes.
And was anyone else in Will's apartment?
Yes.
Who else was there?
A lady named Shelley.
And how long were you in Will's apartment?
I stayed with him for 2 to like 2.5 days. And I left. Yeah.
So from when you woke up and you got into a fight with Mr. Walker and you went down to Will's apartment on the first floor, how long were you down there?
I stayed with Will for like.
These questions were supposed to be based on my questions, counsel. You're going into a whole different area now.
I can wrap it up, Your Honor. Just one more question on that line. So from when you went down to Will's to when you came back upstairs and Mr. Walker pushed you, how long was that?
Excuse me?
Are you saying it was 2.5 days from when you got into a fight with Mr. Walker and when you woke up to have this fight happening to when you went down to Will's apartment to when you came
No,
back
you asked me
upstairs?
how long did I stay at Will's house? That had nothing to do with what happened on that day.
So what I'm trying to get to is when you left Mr. Walker's apartment and you went down to Will's apartment and then you came back up to Mr. Walker's apartment, how long was that you were down at Will's apartment?
I don't know, I didn't even look at my phone.
Are we talking 10 minutes? Are we talking like 2 hours? Just like approximately?
I didn't have it. I didn't look at the time, I just went upstairs.
All right, nothing further.
Thank you, ma'am. You may step down. Any other witnesses for the people on this case?
No other witnesses for the people on this case, Your Honor.
Any witnesses for the defendant?
No, Your Honor.
People?
Your Honor, at this time, the people reserve any argument to aspect to bind over as charged.
Mr. McGrady?
Your Honor, we would object to the bind over without argument.
All right, the court, after hearing the testimony of the complaining witness, is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint and warrant. The witness indicated that the defendant came at her with a knife in each hand and that she felt afraid at the time. That would put a reasonable person in fear or apprehension of an immediate battery with a dangerous weapon. The court will bind the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date and time will be December 18th, 2023 at 9:00 a.m. Bond will be continued.
Thank you.
Okay, what's the next case we're doing? And Mr. McGrady, you're holding on all 3 cases?
Yes, Your Honor.
What's the next case we're doing?
Defense is ready. The 2 remaining offense dates are October 11th and September 11th. So whichever the people would like to call.
That's what I was asking the people.
Your Honor, we're gonna move forward with the 230
23007-101.
Just did that.
Okay, sorry, ID 230600901.
6009. Okay, Madam Clerk.
Calling case 230-600-6901, the people of the state of Michigan versus Clifton Walker. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, assault with a dangerous weapon, felonious assault. Count 3, domestic violence, second offense notice.
Good afternoon, Your Honor. Madison Oro on behalf of the people requesting permission under MCR 8.120B under the supervision of APA Shelley Green.
Good afternoon, neighborhood. I apologize. Neighborhood Defender Service by Kate DeMont Grady, EP 83667 on behalf of Mr. Clifton Walker, who's present with us here in the courtroom. Mr. Walker, please state your name.
Clifton B. Walker.
Today is the date and time set for preliminary examination on this case as well. Are we ready to proceed?
People are ready to proceed, Your Honor.
How many witnesses on this case?
One witness, Your Honor.
Okay, call your witness.
The people call Latasha Hayes to the stand.
Please raise your right hand again, ma'am. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please resume the witness stand. You may begin when you're ready.
Thank you, Your Honor. Okay, can you please state your name for the record again, please?
Latasha Hayes.
Your Honor, can I just have one moment? Sorry, I'm just having my computer loading.
Okay.
Thank you. Okay, Ms. Hayes, I want to draw your attention to September 11th of this year. Where were you on that day?
I was at 2258 West Grand Boulevard, and I had an appointment about 9:30 at Cluster.
Okay, and does that is that an apartment or a home?
What, 2258?
Yeah.
Apartment.
Okay, and who does that apartment belong to?
My significant other.
And how long did you and your significant other how long have you guys been in a relationship for?
About 18 years.
Okay, and do you see Mr. Walker, the person that you've identified as your significant other in the courtroom here today?
Yes.
Can you please point to him and identify a piece of clothing that he's wearing?
He's Nashville's attorney in the Green Bay County.
Okay, thank you. Your Honor, please let the record reflect that the defendant has been identified.
So noted.
Thanks. So did something happen on this date? Oh, I'm sorry. I want to go back to the address that you gave me very briefly. Just to clarify, is that address in the city of Detroit?
Yes.
Oh, Wayne County?
Yes.
Thank you. Now I want to jump forward again. So I just want to discuss, did something happen on September 11th that brings you into court today?
Yes.
And what happened on that day?
I got into a fight with Mr. Walker.
Okay, and when you say fight, was this a verbal argument?
He got verbal in with the physical.
Okay, and what was the verbal argument about?
He accused me of dating someone, and he said I did some things and I didn't do in the apartment, so he got mad about it.
Okay, and so you stated, that the, argument eventually became it became a nonverbal argument, and so when it was no longer a verbal argument, what happened?
He came at me, pushed me, was punching me in my body, and he hit me with a, phone cord, where I had a wrap off my chest. Prior to 2 days before that, I told him about him hitting the golf club, he had took my phone. I couldn't get it back till the day.
Okay, so you stated that, he hit you with a phone cord?
He wanted to punch me and threatened me, and he hit me with a phone cord.
Okay, can you explain to the court a little bit on what that phone cord looked like?
It was black.
Black, and if you can, guess, how long would you say the cord was? Short, really long, a super long cord, like a 10
That one was real long.
Okay.
It was long enough.
Okay, thank you. And just to clarify for the court one more time, can you please state what Mr. Walker was doing to you with that cord?
He hit me on my left side of my chest where I had a whole wet.
Okay, so just for the record, you're pointing to the left side of your chest?
Yes.
Okay. And you stated, that he was, hitting and kicking you, and where was he hitting and kicking you at?
In my face and body shots and all in my phone.
Okay, and was, if you can remember, were his, fists closed or open?
Close.
Your Honor, can I just have one moment, please?
Okay.
Ms. Hayes, when the defendant hit you with this cord, was there a mark left on your skin?
Yes.
Okay, did you receive any treatment for that?
Yes.
Okay, and what treatment did you receive?
When I went to Buffalo, he had my phone, he had took off my phone. I was able to use the phone upstairs. I called my sisters, but one of them was on the phone with me at the time. And I called the other ones that night. I called police there, and they came to me.
Okay, can you explain to me a little bit what Mr. Walker's demeanor was like when he was doing this, when he was using the cord and hitting you and kicking you?
He was a little man cursing at me, he kept saying I was doing things, I kept telling him I didn't do anything, I was lying.
Okay, and in that moment, what were you feeling like? What were you thinking?
I was scared and crying because he should be fighting me. But he wouldn't stop, I had him to stop. It took him a minute to stop. He didn't stop till like close to the time for me to go to Buffalo. Thank God I had to go to Buffalo. That's when he took me. My other metro phone, my tablet, and my purse, and he went in and get under.
Okay. I do not believe I have any more questions at this moment for this witness.
Cross-exam.
Good afternoon, Ms. Hayes. So I'm going to ask you some more questions, just like before. If you don't understand the question or something's confusing, just let me know and I'll rephrase, okay? So on September 11th, you were at the apartment with Mr. Walker, 403.
Yeah.
And that's when you say that Mr. Walker punched you?
Yes.
And where he punched you in your face?
He slapped me in my face, he was punching me like right shots and went on to my head.
Okay, so how many times did he slap you in your face?
About four.
About four times. And that is a slap with an open hand?
Yes.
And did he slap your right side of your face or your left side of your face?
He slapped my whole face like in my face.
So slap your whole face 4 times.
Yes.
And then with a open or closed fist, he hit your body. Closed fist. And how many times did he hit your body?
Oh, I can only remember like 5 or 6.
5 or 6, okay. And where on your body?
And body shot to my here in my stomach.
And you're pointing to your
My sides and my stomach.
your sides and your stomach.
Yes.
Okay, so 5 or 6 body shots to your sides and your stomach with a closed fist.
Yes.
And at this point, are you seated, standing, lying down?
He was punching me, I kneeled down and balled up. I had to protect my face because he doesn't hit.
So-
Let it forward.
When it started, when Mr. Walker, when you're alleging he started doing these things to you, where were you in the apartment?
And there
So describe the bedroom to me.
is, a closet to the left. It's a big dresser. You come in the doors, the bed, and they had a small dresser with, TV, windows in the wall.
So when you say these things started happening, where were you in the bedroom?
I was on the bed at first, and then I stood up, he came at me. I was like, right towards the wall.
Towards the wall, so you stood up, and when he slapped you, were you standing or seated?
Standing.
Okay. And then when you're saying he punched your body, were you still standing?
No, I was falling.
So you were on the ground,
Almost.
on the ground.
Yes.
And this cord, what color was the cord?
But
And how long was it?
I didn't measure it, it was long enough.
Would you say it was about 3 feet long? Not that long. So maybe a foot long?
I didn't measure. It wasn't a short, so it was long enough, he gets it over and hit me in my chest.
Okay. So he hit you and you, before on the direct, you made a motion to the left chest area, is that right?
Yes.
So that's where you're saying he hit you with the cord?
Yes.
And that there was a mark that was left from the cord?
Yes.
And did you receive medical treatment for that mark?
Yes.
And that medical treatment was at Henry Ford?
Yes.
So you mentioned that you called your sister that morning.
Yes.
Which sister did you call?
Marva.
Marla? Marva.
I called my other sister and I got down to the phone.
So you called Marva and you called her on your phone?
Yeah.
On your minutes phone or your other phone?
My minute phone.
Okay. And where were you in the apartment when you called Marva?
In the bedroom.
And where was Mr. Walker?
In
the bedroom? And when he hit you with a cord, what were you wearing?
I just had on my pants, I had a shirt. I was getting dressed. with my family.
So you and Mr. Walker then went to your appointment?
Yes.
And how did you get there?
Well, it's down the street from me.
So you walked to, and what's the name of the place?
Crossroads.
Crossroads? Okay. So you walked to Crossroads together.
Yeah.
And what time was your appointment?
I think 9:30 to 5.
And you called the police from Crossroads?
Yes.
Did you call the police when you were at the apartment as well?
No. Yeah, I didn't have my phone today.
Did he take your phone before or after you called Marva?
After.
So you still had your minutes phone though, right?
No, he took.
You took both phones?
Yeah, to my metro and my name. I asked for it back and Buffalo, and they gave it to me.
So when you left the apartment that day, you and Mr. Walker walked to Crossroads, and then you had your appointment.
I didn't do my appointment. I had called my sisters and the police.
So you didn't go to your appointment?
I went, but I didn't get the stuff, so I wasn't the one that's supposed to walk out.
So where did you go after that?
To the hospital.
To Henry Ford Hospital?
Yes.
Were you admitted?
I stayed till the next day, somewhere like 3 or 4 o'clock the next day.
Did the doctor take any pictures of your body?
X-rays.
They took what?
X-rays,
X-rays? Did they take any photographs?
like pictures?
Yes.
No, they took X-rays.
What areas of your body did they X-ray?
My chest, my abdomen.
And that day, had you, had anything to drink that morning?
No,
Had you smoked any marijuana that morning? Had you smoked any crack cocaine that morning? Had you taken any of your medications that you're prescribed?
no,
You didn't take any of your medications?
no. I didn't have them yet.
You didn't have the medications?
I didn't have them yet. I had to go pick up my prescriptions. I didn't have them.
Understood. And when you were released from the hospital that evening, you went back to Mr. Walker's apartment, correct?
It wasn't that easy for that.
The next day, you went back to Mr. Walker's apartment?
I didn't, I went to his friend's house. When I went to his apartment, I only stayed there 5 minutes and asked him, look, it was the best. And went downstairs to his other friend, I was definitely eating all that.
Okay, which friend did you go to?
I went to Will's house first, he got made out of down there.
And that's Will on the first floor?
Yeah.
Are there any other details from that day that you haven't told the police or testified to here to in court?
No.
That's everything that you remember?
Yeah.
Any other questions?
No more
Ms. DeMont
questions.
Grady? Any redirect?
Just very briefly, Your Honor. Ms. Hayes, did you ever get your phone back in your possession?
Later that morning, in the morning when I came back to the apartment, I like 3 o'clock.
Okay, and so
He gave me the blue man.
how did you get that phone back?
I went to the apartment.
And he gave it to you, or it was just there?
He had asked my other phone where my medical, so he gave me the blue man already. Told me to come upstairs, I went downstairs to another house, got something to eat. And me and him were fighting because he cheated on me and stuff, and was none of my stuff, no clothes, nothing.
Okay.
So I had no leave.
Okay, so you got it the next day. Okay, thank you.
All right, thank you, ma'am. You may step down once more. Any other witnesses for the people?
No other witnesses for the people, Your Honor.
No witnesses
Any
for
witnesses?
defense?
People?
Your Honor, at this time, we asked, we reserve any argument, and we asked that count 1 and count 3 and the have for notice, be bound over to the circuit court.
You said count 1 and count 3. There's a count 2 that you're not moving a bind over on?
Yes, Your Honor.
What's count 2?
Count 2 was, assault with a dangerous weapon, which was a piece of hot metal that, we didn't receive any testimony regarding, so with that, we would be dismissing that count.
Okay. Mr. Mike Grady?
Defense would object to the bind over and without argument, and obviously would join in or move to dismiss count 2.
All right, the court will bind over on count 1 and count 3, finding that those charges were committed in the city of Detroit and that there's probable cause to believe this defendant committed them. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be December 18th, 2023 at 9:00 a.m. This bond will be continued. All right, one more case, right?
Yes,
Let's do it. Let's call the last case.
Calling case 230-600-6801, the people of the state of Michigan versus Clifton Walker. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence, second offense notice. Today is the date and time for an exam. Appearances, please.
Good afternoon, Your Honor. Shelley Drink for the People, key number 60249.
And good afternoon, Neighborhood Defender Service by Kate Demont Grady, P 83667, on behalf of Mr. Clifton Walker, who is present with us here in the courtroom. Mr. Walker, please state your name for the court.
Clifton Walker again, Young.
Today is the date and time set for preliminary examination. Are we ready to proceed?
Yes, Judge.
How many witnesses?
One witness, Your Honor. That witness being a Ms. Tasha Hicks.
Okay, call your witness.
People would call Ms. Natasha Hicks.
One last time, Ms. Hayes, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you know the routine. Go ahead. Have a seat in the witness box. You may begin when you're ready, Ms. Drain.
Thank you.
What are we waiting on?
Me. All right. Good morning. Please state your name once again for the record.
Tasha.
All right. Ms. Hayes, I want to bring your, you know, you were already here court, in this court 2 previous times testifying about certain incidences, correct?
Yeah.
Okay. And the first one you testified was about the incident that happened on October 7th, correct?
Yeah.
And the second one was about September 11th, correct?
Yes.
Okay. Now I'm going to be asking you about the incident that occurred on October 11th. Do you remember that date?
Yes.
Okay. All right. Bringing your attention back to that date, where were you?
I was in his friend's house. He came and knocked on the door and we were in the home.
Okay. So whose residence were you at?
I was at his friend's, Will.
You were at Will's residence. Okay. And what were you doing at Will's residence?
He let me stay there when Mr. Walker didn't know. I was there for like 10 days.
Okay. And you said Mr. Walker. What is Mr. Walker's first name?
Clifton.
Okay. Thank you. And what is your relationship to Mr. Clifton Walker?
We was in relationship for about 18 years. I'm the mother of the kids.
All right. And do you see Mr. Walker in the courtroom here today?
Yes.
For identification purposes, could you indicate where he is and what he's wearing today?
Yes, he's next to his attorney. He got from his way.
Thank you. Your Honor, please, if this record reflects that the student has identified the defendant, Clifton Walker.
So noted.
Thank you. All right. Ms. Hayes, when you were at Will's house or Will's apartment, excuse me, what happened while you were there?
On the 11th?
On the 11th, yes.
He had spoke to Will and he was mad I was down there and told me he told Will to tell me that he had already got my prescriptions from the pharmacy stolen.
Okay, now let me just ask you one thing. So just so that we all know who you're talking about, can you just use the names of who you're talking about?
Mr. Walker.
Thank you. Okay, so Mr. Walker was talking to Will?
Yes.
Okay, and what was he saying to Will?
He told Will to tell me that I need to go to the pharmacy. He had already went and stole my meds and all my medicine.
Okay, and what happened after that?
But Will had, when I woke up, Will had, told me, and I got ready to leave the apartment.
Okay, hold on a second. So when you woke up, were you still at Will's apartment?
Yes.
Okay. And did Will say something to you?
Yes.
Okay, based on what Will said to you, what did you do, if anything?
I was upset. I just asked, Shelley if I could use the phone to call my pharmacy.
Okay, and did you call the pharmacy?
Yes, I did.
Okay, did you get information from the pharmacy?
Yes, I did.
Okay, and based on that, what did you do, if anything?
I voted down, and when Will was ready to leave to go to Buffalo, I was supposed to be with him. Mr. Walker came a little bit after that and knocked on the door.
Okay, and were you still at Will's apartment at that time?
Yes.
And so you're saying Clifton Walker came to Will's door?
Yes.
What happened when he did that?
He was been telling me to come on. I slammed the door back, but until Will opened the door, so come out of the apartment.
Okay, and did you come out of Will's apartment?
Yes.
Okay, what happened after that?
Mr. Walker came in my face, walked up on me and called me vicious and stuff. He told his friend, tried to get his friend to get a weapon for me. He pushed me in the hallway, told me get you out the apartment. He tried to get a gun to shoot the apartment. That's when I started yelling and stuff in the hallway. To where the manager and owner came on and took me to the office.
Okay, what happened after that?
I called my sister and the police.
Okay, and what happened after that?
The police came, they talked to me, they went upstairs, tried to, talk to Mr. Walker. I don't know if they was receiving or not, but I was in the hallway. Probably not, because they didn't take him out. But they talked to me, and I had to file reports, and they made me go to a safe place.
Okay, so what you're saying happened is you were in Will's apartment, is that right?
Yes.
Okay, and then Clifton Walker came and wanted you to come out of the apartment.
Yes.
Okay, and you eventually did come out of the apartment. Okay, and you heard Will trying to get something else? Trying to get a weapon, is that what you said?
No.
Okay, what did you say?
I said, Mr. Walker called his friend, he put his friend in it, which we was cool with, and he tried to get a weapon from me, and like I said, he came approaching me, yelling at me, and said, bitch, why you scared? I told Will and I'm not scared, I don't wanna be, walking the two hops, got back and forth, getting into a fight. He pushed me, he tried to get a gun to hurt me, and bitch, you gonna get out here today, you gonna get out the apartment today, that's what he said.
Who pushed you?
Mr. Walker.
Okay, what did you say about a gun? I didn't quite hear what you said.
He was trying to get the gun to hurt me, he said he's gonna kill me.
Okay, and what, did you see a gun around there?
No, thank God I started yelling and I went and took it off.
Okay. Okay, so he pushed you. And then you ran and then you,
The manager and the owner came when I was yelling.
Okay. And did anything else happen on that day?
No.
Okay, were you injured?
I got enough. They didn't call the ambulance, they just took me to a safe place.
Okay. Okay, I have no further questions.
Cross-exam.
Thank you. Good afternoon, Ms. Hayes. I just have a few more questions again with the board. So you said that the apartment manager came out.
Yeah.
And the owner.
Yeah.
And what are the names of the apartment manager and owner?
Jasmine, I don't know.
Jasmine, and is it a man or a woman, the other one?
A woman. I don't know her name, I never did.
Okay, is Jasmine the owner or the apartment manager?
The manager.
And was there anyone else in Will's apartment when you woke up?
Yes.
So you were there and Will was there?
And Shelly.
Shelly?
Yes.
Okay. Anyone else?
No.
No further questions, Your Honor.
Any redirect?
Nothing further, Your Honor.
Thank you, ma'am. You may step down. Any other witnesses for the people?
No further witnesses, Your Honor.
Any witnesses for the defendant?
No, Your Honor.
Okay, people?
Thank you, Your Honor. This case is charged as count 1, felonious assault with a knife, and count 2, domestic violence, second offense notice, and a habitual offender, fourth offense notice. Your Honor, based on the testimony that was, stated on the record by the complainant, she only testified to the aspect of domestic violence. She did not indicate anything about any knife in this specific incident. So I am only moving, well, I'm actually not really moving for a bind over. I cannot go forward on count 1 because there was no testimony to substantiate count 1. I can only ask that this matter, that count be dismissed and that we only go forward on count 2, which is domestic violence, second offense notice, which is a 1-year misdemeanor.
All right, the court will dismiss count 1 for insufficient evidence. That leaves the 1 count of domestic violence. That has to go on Judge Austin Garrett's docket. We'll get a pretrial for that count after my trusty friend there, Gwen, calls Judge Garrett's courtroom and gets a date.
Okay, 1 moment.
I need a dismissal, Mr. DeMont Grady. That's the count 1.
Yes, Your Honor.
Okay, let's move on to our homicide while Mr. DeMont Grady waits on that date with her client.
Thank you, Judge.
Good afternoon, Mr. Hart.
Hey,
Good
Judge,
afternoon, Mr. Slaw.
Hello, Judge.
Yes, sir. I'm on Zoom because you guys make me sick.
I liked it. Well, I don't look, I understand.
Your Honor, if I may.
Yes.
The case where there are 2 FA counts and 1 was dismissed, do I need to do a dismissal form for that 1 count as well?
Yes, you do.
Okay, filling that out right now.
All right.
So it hit you pretty hard, huh?
Never had COVID before.
Yeah.
Not as bad as I thought. Just have the sniffles. Uh-oh, what happened? Are you guys still there? I don't know what happened there.
Not a clue.
Okay.
Ms. Grady?
Okay, let's call the next case, please.
Thank you. Calling case 230-599-1801, the people of the state of Michigan versus Aaron Tisdale. The defendant is charged with count 1, homicide, murder, first degree premeditated. The defendant has a habitual court offense notice. Today's the date and time for exam. Here's the case.
Good afternoon, Your Honor. Anna Bickerstaff on behalf of the people, P82215.
Good afternoon, Your Honor. Mark Hart appearing on behalf of Mr. Tisdale, but he's not here. He's in custody, but he's not here.
Where's Mr. Tisdale, folks?
Waiting on him. They bringing him up.
Oh, okay. He is in the building though, right?
Yes, sir.
Okay. Okay, we can call it. Or did we call it already?
We called it already, Judge.
All right. Appearances for the record, please.
Anna Bickerstaff on behalf of the people.
Good afternoon, Your Honor. Mark Hart appearing on behalf of Mr. Tisdale.
Tell us your name, Mr. Tisdale.
Aaron Tisdale.
This matter was held in part and continued to today's date. Are we ready to proceed?
Yes, Judge.
So the court appointed counsel for the witness who was testifying. That would be you, Mr. Schloff?
It would, Your Honor. And for the record, James Schloff on behalf of the witness. As the court and all the parties know, I've been dropped in the middle of this. I don't have the advantage of being here for the first day of testimony. But based on my reading a limited amount of the discovery in this matter and speaking to my clients, I had some concerns whether she should have received immunity or not. So I raised these concerns with the prosecution, and I believe that they might have some further statement on that.
Ms. Bickerstaff?
Judge, yes, after speaking with the supervisor, Mr. Schloff is asking for immunity, and the court is willing to grant that immunity after Mr. Schloff makes his argument. People would have no objection giving the witness immunity.
Okay. And Mr. Schloff, you had an opportunity to discuss that with your client?
I have, Your Honor, and explained it to her the best I can. I think she understands that. But it's based on some of the actions she took, perhaps during the incident and a few actions after the incident that give rise to my concern.
Okay. Well, she's been given immunity by the people, so let's move forward. Where's the witness?
Mr. Hart. No. Oh, you have anything to say on this?
Judge, the only thing I would add, I really don't have a dog in this fight with regard to whether you grant immunity. However, the statute requires that the prosecutor file an application outlining the reasons that they believe immunity is in order. So I would ask that that procedure be followed, even if we're not going to do that today.
Judge, I am emailing those documents to you now.
Okay. Let's have the witness. Here she comes. Ma'am, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, give your name and spelling of your name to the young lady that's seated in front of you. Okay, please have a seat in the witness stand. Just like the last time, speak directly into the microphone for us so we can all hear you, okay? You may begin when you're ready.
Thank you, Judge. Ms. Tanaka, am I saying that right?
Yeah.
Right after this person that got hit by the car walked up to the window, how long was it before they were hit by the car?
Within a couple seconds.
Okay. And the person, how long would you say the person was up at the car talking or leaning into the car?
Couple seconds.
So from the time you guys knew there was somebody at the car to the time somebody got hit by the car wasn't more than 3 or 4 seconds. Fair statement?
Yes.
How did Mr. Tisdale react when he saw the person at the side of the car?
He was angry. He told the person to leave his car.
When you say angry, can you be more specific?
Just was angry. Told him to leave. Didn't want him near the car.
Did now you've known Mr. Tisdale for a long time, right?
Yes.
Okay, and you know he's got something of a temper to begin with, right?
Yes.
And did you tell the police that Mr. Tisdale snapped as soon as he saw that who it was that was at the side of the car?
Yes.
By the way, when we say side of the car, that person actually walked up to the front passenger window and kind of leaned down to either talk or do something, right?
Yes.
All right, and then you say that Mr. Tisdale snapped, is that right?
Yes.
Freaked out, would that be a fair statement?
Yes.
Blind fury, fair statement?
Yes.
Didn't you say that despite the fact, or is it in fact true that despite the fact that you've seen him very angry in the past, you've never seen him as angry as he was at that moment, is that correct?
Yes.
You made a whole lot of statements to the police in the first interview you gave, is that correct?
Yes.
And would it be fair to say that out of the 70 or 75 minute interview, you spent about the first 60 or thereabouts telling a different story than you're telling now, right?
Yes.
And you were trying to be convincing in that statement, right?
Yes.
On direct examination, or maybe it was on my cross, I don't know. Did you testify, last time we were here in court, that you didn't know anything about any drugs or drug paraphernalia that was in the car?
Yeah.
Okay. Did you know about whether there were drugs or drug paraphernalia in the car?
Mhm.
You never ultimately told the police that, yeah, you know, there was drug paraphernalia in the car?
Yeah, I did.
Pardon me?
Yeah.
Tell the police that, the person that got hit by the front of the car and then by the back of the car?
No, by the front.
You didn't tell that to the police?
No.
Okay. When you were first taken into custody, were you afraid you might be held responsible for what happened?
No.
Not at all?
No.
Did the police tell you, in order to get you to testify, I'm sorry, in order to get you to give a statement to them that they weren't going to prosecute you because you were just a passenger of the car?
No.
They never told you that?
No.
Did they tell you that you would not be getting in trouble because you were the passenger in the car?
Yes.
They did tell you. And yet, even knowing that, you continued on with the first 50 or 60 minutes of the statement you gave to the police, right?
Yes.
Did you ask, I'm sorry, Judge. Did you ask the police in your first statement to the police whether anybody got hurt as a result of this event?
Yes.
So you acted as though you had no idea that somebody had actually even gotten hurt?
Yes.
Did the police ask you if you could prove that you were at home all morning before Mr. Tesdale came to pick you up just before the event?
Yes, they asked me.
What did you say?
I said I was at home in the morning.
Okay. Did you say you were with somebody else?
No, I just said I was at home.
By yourself?
Yes.
You never said you were home with somebody else?
No.
Did you encourage them to go talk to anybody to confirm that you were at home with somebody when this all happened?
It was the only person that is at the house is his mom.
Okay, but my question is, did you tell the police, I wasn't there?
Yes, I did at first, yes.
And then you told them, go talk to her, she'll tell you, right?
Yes.
But you forgot about that a minute ago, right? Right? Did you tell the police that Mr. Tisdale was wearing a gray hoodie on the day of the event?
Green.
Did the police tell you that if you were lying, you could get charged?
Yes.
And even after they told you that, you continued on with the story about how you hadn't been there and didn't know anything about what happened, right?
Yes.
Did you initially tell the police that you had no idea who the woman was or the person was that Mr. Tisdale was supposed to have gone to pick up?
Yes.
And did you ultimately tell them that person's name?
Yeah.
Did you ultimately tell them the person you were referring to?
Yes.
Did you tell the police that my client told you that he ran into something and you didn't know it until he told you that? Is that correct?
Yes.
And then the police again asked you if Mr. Tisdale hustles or sells drugs, and you said, yeah, he hustles, right?
Yes.
But prior to that, you had told them that you had no idea whether he sold drugs or if he hustles on the street.
Yeah.
Did the police show you a picture of you getting out of Mr. Tisdale's car while you were in the driveway at his house?
Yes.
And you told them that picture was not about what was going on during this event, right? But you presented it as though that picture had nothing to do with you
Yes.
being with Mr. Tisdale at the time of the event. At some point towards the end of your interview, would it be fair to say that the police kind of changed their attitude with you?
No.
Did at any point the police tell you that they believed you were lying?
Yes.
Okay. And did the police tell you that if you're lying, you're no longer going to be a witness and that you could get charged?
Judge, this is asked and answered.
That was.
Okay. You said it was asked and answered, Mr. Hart?
No, it wasn't.
Go ahead, answer the question. Overruled.
No.
No what? Are you saying no, the police never told you that if you're lying to them, then you could get charged in the case or that you would get in trouble for what happened?
Yes.
Now that has been asked and answered.
Okay. Did you tell the police that nothing in the car was yours and that they could go ahead and fingerprint whatever they wanted?
Yes.
How many officers?
Three.
Okay. And there was one that came in, a male officer that came in towards the end of the interview, is that correct?
Yes.
And you basically repeated the story you had been giving to the first two officers when you first started talking to the third officer. Is that a fair statement?
Yeah.
Did the police ever ask you whether or not Mr. Tisdale said anything to you about what had happened and you told them he did not?
Yeah.
Did you tell the police that you had no knowledge of what actually happened?
Yes.
Did you say to the police, quote, I never went with Mr. Tisdale to the laundromat, or never went to the laundromat with him?
Yes.
Have you ever been convicted of any crimes involving theft, dishonesty, or false statement in the last 10 years?
Yeah.
What was that?
Some probation for 2 years.
For how many different crimes?
2.
Those 2 crimes both involve theft or false statement, correct? Did Mr. Even if somebody wanted to accept your latter version of the events, given the very short amount of time that you said it was between the time the man walked up to the window and the time the man got hit by a car, did Mr. Tisdale have sufficient time to think about what he was really doing?
Judge, I would object, this witness lacks personal knowledge, she can't say what the defendant was thinking.
Sustain.
I agree. You would admit, however, that it was almost instantaneous, right?
Judge, I would object to the witness testifying to what's in the video. The video speaks for itself. There's a timestamp on the video. We can see how much time passed.
That's all well and good, but she's still entitled to give her view of how long that was.
I don't care what her view is, though, Mr. Hart. Sustain.
Thank you.
Why'd you change your story? But it wasn't the right thing to do all up until that time?
Judge, I would object, I think that's argumentative.
You didn't say that until they.
Argumentative, rephrase.
I'll go, yeah, I'll move on. You never said that until they told you that you could get charged. Basically, unless you cooperate, right?
Judge, I would object, I think that's a mischaracterization of the testimony.
You didn't change your story until after they told you you could get charged if they could show you were lying, correct?
They told me that at the beginning.
Okay, and they told you that shortly before you changed the story again, correct?
They told me multiple times.
Okay. I think we're close, Judge. Give me a moment. When you were interviewed the first time, did you ask the police why you were there?
Yeah.
And did you ask the police why Mr. Tisdale got arrested?
Yes.
And you asked those questions as though you didn't know,
Yes.
right? Did you tell the police, I don't know why we're here?
Judge, I object, it's asked and answered.
I'll take it. Go ahead.
Did you tell the police during your first interview that I don't know why we're here? You and Mr. Tisdale?
Yes.
And were you crying during the first portion of it?
Yes.
I could have one moment, Judge. I have no more questions, Judge. Thanks.
Any redirect?
Yes, Judge, thank you. When you told the police that Aaron hustles, what did you mean by hustles?
Transactions, how it works.
So you knew Aaron was selling drugs?
Yes.
Why did you think you and Aaron were going to the laundromat back on this day?
Somebody had called for some drugs.
So it'd be fair to say your primary intention on this day was not to do laundry, correct? When you went to the laundromat?
Objection needed.
Yes.
Sustain. Rephrase.
What was the main reason you and Aaron went to the laundromat back on this day? Now, you had previously told us last week that you had been to the laundromat a couple times on this day. Do you remember saying that?
Yes.
Was that accurate?
Yes.
How many trips did you make to the laundromat on this day?
3.
For what reason?
Drugs.
Now, last week, defense counsel was asking you about some still pictures from the surveillance video. Do you remember that?
Yes.
I'm going to be fair to say you recognize these because you were there in person.
Objection needed.
Yes.
Sustain. Rephrase.
How is it that you're able to recognize who's in these pictures?
Because I was there.
In person?
In person.
Thank you. Now, last week, defense counsel was asking you about throwing some items. Do you remember that?
Yes.
Throwing some items when you were at the LA Insurance. Do you recall that testimony?
Yes.
Did you throw something?
Not long.
Did you throw anything else?
No, not even.
Did you throw carpet cleaner?
Yes. Yes, I did have a
And did you tell the police that you threw carpet cleaner?
Yeah. Prior to this day even happening, there was carpet cleaner on the ground.
Right, so explain what happened then.
There was carpet cleaner on the ground and they thought it was a substance, but because there was substance already being in the car on top of me doing carpet cleaner on the ground. That was prior to the police walking up. I had my wallet in the back when they walked up.
Okay, so what happens when you throw your wallet in the back?
The police opened the door.
Let me ask you this. When you throw your wallet in the back, does it hit the floor of the car?
Yes.
Does something happen or do you see anything when the wallet hits the floor of the car?
Carpet cleaner going in there.
Okay. Why did you throw your wallet?
I got scared. I didn't know what was going on.
Do you know if there were drugs in the car?
Yeah.
Okay. Whose drugs were those? Now, do you recall last week defense counsel was asking you about the statements you gave to the police, correct?
Yeah.
All right. And he indicated you gave a statement on November 11th, is that correct?
Yes.
Would it be fair to say you spoke with police officers and then they left you alone in that room?
Yes.
And then you spoke to some different combination of officers after that?
Yes.
So are you counting those as kind of two different statements on the 11th?
Judge, objection needed.
I asked her, are you considering those two different statements?
I'll take that. Overruled. Go ahead.
And then you told us you didn't want to talk at the DVC, correct?
Yes.
Objection needed.
Don't lead, Ms. Bickerstaff.
Sorry, Judge. Do you know when the next time you spoke to the police was? After you told them you didn't want to speak?
Right before they released me on DVC, about my phone.
You know, was that, like, what span of time that would have been?
The maximum hours me being able to be there, so. Third day,
Do you believe that could be November 13th?
yes.
Well, that's not leading.
You sure?
I have no further questions, thank you.
Judge, I just have a handful of questions.
Oh, no. I think we've heard enough, haven't we? But if you must, Mr. Hart, go ahead.
I promise I'll be short. Why did you go with Mr. Tisdale to sell drugs?
Live with him and work
So do you go with him every time he goes to sell drugs?
with him often.
And the police were piling into the parking lot, multiple cars, correct?
Yeah.
Okay. And at some point while the police were in there, you tossed what you're now saying is your wallet, right?
Yes.
Why did you toss your wallet?
Because this is asked and answered.
No, she asked if she tossed her wallet. I'm asking why she tossed her wallet.
I asked why, and she said because she.
Let me ask, why do I care? Why is that relevant?
It's relevant to undermining her credibility from before, that she had no idea what was going on and that she could be in trouble. If she didn't have any idea if there was something untoward that had happened or could happen to her, why would she worry about tossing her wallet?
I don't think it's relevant. I think you've already made your point, Mr. Hart. I get it.
Thank you, Judge. Anything else? Nothing further. Thank you.
All right. Thank you, ma'am. Oh, I do have one question for you, ma'am. Now, it's been brought to light that you were less than honest, according to you, when you initially spoke to the police. Is that right?
Yes.
Are you being honest now under oath?
Yes.
Are you being honest when you said that it was the defendant, what's his name, Mr. Tisdale, that was driving the vehicle that struck that man and rode over him?
Yes.
Well, Judge,
Yes.
I don't know how I can lodge an objection to a judge question, but
you can say objection.
Okay, objection.
What's your objection?
Just because she says, "Oh, I was being honest," now that doesn't make it so. So how is that relevant?
What's your legal objection?
Irrelevant.
Overruled. That was all I have. All right. Thank you, ma'am. You may step down.
Your Honor, is she excused for the rest of the hearing?
Yeah, I think we're done, aren't we?
Yeah. And may I be excused too?
Yes, sir. I appreciate you, Mr. Slough. Thank you very much.
Yeah. Judge, did we place on the record that she was granted immunity to continue her testimony today?
I think we did. That was a lengthy discussion before she testified, but if it wasn't clear, then not only did she testify under the immunity statute, but that the people are going to submit the paperwork as such.
Yeah, I just didn't remember if that was all on record. Okay, thank you.
Okay, thank you. Ms. Bickerstaff?
Judge, the people have no further witnesses at this time.
Any witnesses, Mr. Hart?
None, Judge.
People?
Judge, the people would move to bind the defendant over on the compensating the information. Judge, can I have permission to share my screen briefly?
Sure. We need to, let me see, let me make you a co-host. Give me a second. Okay, go ahead.
For the record, I'm publishing People's Exhibit 2 at 1 minute and 35 seconds. And Judge, in this video, the witness did testify that this is the defendant's vehicle at this point and the victim coming up to the passenger side of the vehicle. And we can see the victim then backing up and then driving over the victim in this case with both the front and rear tires and then driving away. And then we see the vehicle pass the side camera on the side of the parking lot. The witness did tell us that this was the defendant, Mr. Tisdale, driving his vehicle, and the witness was present in the passenger seat. Based on the testimony from the witness and the timing that we see in the video here, the multiple seconds that occurred of the defendant backing up in preparation to then drive over the victim in this case, the people do believe that they've proven to a probable cause standard for premeditated murder based on the witness testimony and the time that we can see in the video that it took for the defendant to drive over the victim. And I reserve any other argument for that. Thank you.
Mr. Hart?
Judge, there are a number of potential defenses in this case, most of which are not germane to a bind-over decision. I would, however, object to the bind-over on first-degree premeditated murder. I would indicate to the court that in my analysis of the same video that you were just shown again, it was literally 4, maybe 5 seconds between the time that person walked up to the window and the time that that person got run over. I would also indicate to the court that there is no way under the statute for what constitutes premeditation and deliberation. That is an opportunity to give your conduct a second thought and the other criterion that are in the jury instruction in the statute. It's my position there was not enough time, even objectively looking at the video, for somebody to have had time to premeditate and deliberate, and therefore I would ask that that charge be reduced to murder. Thanks.
All right, so reasonable minds can disagree in that Mr. Hart and Ms. Bickerstaff disagree with each other. And in fact, I disagree with you as well, Mr. Hart. As we know, there's no allotted time for premeditation. It could be months, it can be weeks, it could be days, it could be hours, it can be minutes, it can be seconds, just so long as there's time to take a second look to those actions before those actions are taken. Based on the video that I've seen, it appears that the defendant had more than ample opportunity to take a look at his actions before he took them, and his intentions appear to be very direct, and he achieved those objectives in what he was trying to do. I think it's at least a question of fact to be determined by a trier of fact. As such, the court is satisfied the people have met their burden of probable cause as it relates to the charges contained in the complaint and warrant. The court finds those charges were committed in the city of Detroit, and the court finds probable cause to believe this defendant committed them. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date, and time will be December 18th, 2023 at 9:00 a.m. Defendant would be remanded to the custody of the Wayne County Sheriff. Thank you.
Thank you.
Okay, what did he say?
December 18th.
And Judge, do we need to order a copy of the transcripts here, or should I wait till we get up to circuit court?
Talk to the court reporter.
Will do. Thank you.
All right. Thank you. Have a good day, guys.
You too.
Feel better, Your Honor.
I'm trying. Thanks. Well, everybody, that concludes the docket for today. Hope to see you tomorrow. Same bat station, same bat time. Have a good day. That's an order.
Take care, Your Honor.
You too.